Welcome to Convocation. Welcome to anyone who's joining us via public webcast today. This will be our third webcast as part of a pilot project to provide online viewing of Convocation, part of our commitment to continued transparency and accessibility around our governance process. And we're also regarding it as a pilot project to determine the level of the profession's interest in Convocation as to whether we continue it or not. And it also gives an up-close look at the way Convocation works and considers policy issues. So I'd like to review instructions for the phone system for those benchers participating by phone. Once we determine who's on the phone, I'll let everyone know that we'll be placing those calling in what we call lecture mode. This means that from our end, we're muting all callers. Once muted, they'll be able to hear the meeting but can't speak, so it's *6 from our end for everyone. When we come out of lecture mode to hear callers who wish to speak, they have to *6 their phones. Unless callers wish to speak, again, please *6 your telephones so we don't have interference. And we'll remind you if we have a problem on this, and I think we're going to thank Barbara Birchie today for assisting us on the phone, having lost Justice Adriana Doyle. Okay, first, the list of people on the phone. Those who indicated they would be: Paul Copeland.
Present.
Thank you. Lee Ferrier.
Yes, here.
Neil Finkelstein. Okay. Patrick Furlong.
On the line, Treasurer.
Thank you. Michael Lerner. Gavin McKenzie.
Present.
Thank you. Ron Maines. Clay Ruby. Jim Scarfone.
Present.
Thank you. Harvey Strasberg.
I love you, Kathy.
Roger Nicketting. Okay. Is there anyone whose name I did not call who is on the phone?
Yes, Julian Porter.
Okay, thank you. You have Mr. Porter. Anyone else? Okay, thank you. Okay, first on our agenda is our election of a new bencher, Justice Adriana Doyle, obviously having moved on. So could I have a motion on that, please? Moved? Okay.
Yes, Treasurer, I so move.
Okay, and Ross Earnshaw is seconding, I understand.
Yes.
Okay, all in favor? And then I think we can welcome Mr. Fleck. Please be seated. Yeah.
Welcome.
I'd also like to advise that we will have guests today at Convocation. Michelle Hollins, President of the Canadian Bar Association. I don't think they're in the room yet. No. And Orlando De Silva, President of the Ontario Bar Association. They will be addressing Convocation later this morning. I'd also like to welcome Tom Conway, past treasurer, and currently president of the Federation of Law Societies. I think this is your first return to Convocation since your end of your term.
Yes, thank you, Treasurer, for the invitation.
Thank you. And Mr. Conway will be addressing Convocation on behalf of the Federation probably early fall. Thank you. Just reporting on some of our activities. I just returned from the Commonwealth Law Conference, which was held in Glasgow, Scotland. Both Tom Conway and Michelle Hollins attended, as well as Laurie Politza, who's a member of the Commonwealth Law Conference Council. Malcolm Mercer, who was on the council, I believe you've just left, is that correct? Also there, Paul Shabas, Jack Braithwaite, and Grant Wedge. I found the conference extremely interesting. It's particularly informative, and I think it gives one a slightly different perspective when you talk about legal problems that we have dealt with or are dealing with, at the same time as hearing how countries who are in a less developed state or developing countries are dealing with problems at the same time. And I think there's a really good opportunity for interchange and, as I say, development of perspective. The theme of the conference was rule of law, and there were some very interesting speakers, particularly focusing on human rights in the plenary sessions. And I'm happy to report further if anybody would like to hear more details. The Commonwealth Magna Carta exhibit is coming to Osgoode Hall, and that exhibit traces legal milestones from the time the Magna Carta was sealed to the signing of the Commonwealth Charter by Her Majesty Queen Elizabeth. That's going to be on display at Osgoode Hall in the Rotunda in the Court of Appeal from May 4th to the 15th. And it was on display in Glasgow, and I think we all found it very helpful. So the exhibit was produced by the Commonwealth Lawyers Association in partnership with the Commonwealth Magistrates and Judges Association and the Commonwealth Legal Education Association. And as you know, this is the 800th anniversary of the Magna Carta, and it will be coming to Toronto on display, I believe, in September, if I'm not, is that correct? So it launches in Ottawa in June. In March, I attended the Federation of Law Society meetings in Ottawa together with our council representative Lori Politza, CEO Rob Lapper, and Director of Policy Jim Vero. And aside from its business meetings, the Federation usually organizes a conference addressing a particular regulatory theme of national importance. At this meeting, the Federation held governance discussions in the context of its governance review with Federation council members, Law Society CEOs, and Law Society presidents and vice presidents, and then a governance workshop for all those participants. And you can have a look at the information report on these meetings at tab 11 of our material. I'd like to particularly thank staff Mary Sheena and Marisha Roman, who were the main organizers of the dinner that we hosted for delegates. It was in the Grand Hall of the Canadian Museum of History in Gatineau, Quebec, and it was very well received, and it took a fair bit of work on their behalf, and I'd like to thank them for it. At the beginning of April, Susan Hare, Grant Wedge, Marisha Roman, and I had the great honor to meet with Grand Council Chief of the Anishinaabe Nation, Patrick Wadase, I'm sorry, I apologize. Wadase Madabi, and Senior Staff and Legal Counsel of the Union of Ontario Indians, and also Chief Mariana Cucci, Councillor Arnold May, and Senior Staff of the Nipissing First Nation in their communities in the North Bay area. And it's my understanding it was the first time that a Law Society treasurer had visited a First Nation territory to discuss access to justice with community leaders. And we very much appreciated the time that Grand Chief Madabi took to meet with us to explain the breadth of issues that he, the members of his council and his staff respond to as they serve 55,000 Anishinaabe people in 39 First Nations across Ontario. It was a very positive dialogue, and we shared a commitment to continue to find a way forward. Later that afternoon, we met with Chief Cucci, Councillor May, and senior staff at Nipissing First Nation Administration Office. Again, I appreciated the time they spent in describing their work in developing their constitution and fish and land resource management laws and their efforts to create a sustainable and self-sufficient community. I think in the course of both meetings, I learned a great deal about their history, their perspectives on governance, education, and justice, both in relation to Canadian law and also their traditional laws. And I think we have a much clearer understanding of what access to justice looks like from their perspective. And this is the first of what I hope will be several meetings with First Nations, Métis, and Inuit leaders in their communities. They're an important first step in the process of renewing our initiatives and supporting improved access to justice for First Nations, Métis, and Inuit people. We also hosted a reception this past Tuesday for the Deb Waywen and Aboriginal Justice Advisory Committees with benchers Janet Leeper and Julian Faulkner. And these are the two committees that were established by the Government of Ontario in response to Mr. Justice Iacobucci's review on First Nations people on juries and the lack of representation there. So we also had a chance to hear from Kimberly Murray, who took on the new position of Assistant Deputy Attorney General for Aboriginal Justice on April the 1st. And this was also a recommendation arising from Justice Iacobucci's report. And I also want to say a particular thank you at this point to Susan Hare, who was a very great assistance in our meetings in North Bay, and really helped lead the discussion and make sure that we were getting the kind of information and detail that we needed to have to understand the issues there. So again, thank you very much, Susan. Turning to updates from the Action Group on Access to Justice, better known as TAG, in March, we were pleased to host a meeting of the National Action Committee. Justice Cromwell, along with representatives across the country, discussed how best to coordinate communication across jurisdictions about access to justice, best practices, and initiatives. And we were very pleased to have the opportunity to highlight our own collaborative, innovative approach to such an esteemed group. We're also happy to advise that last month, Sabrina Dellon joined the Law Society as the full-time manager of TAG with support and funding, importantly, from the Law Foundation of Ontario. There's a report of TAG's recent activities in the convocation materials for this month. I would like to point out that we look forward to seeing you at the May 12th Targeted Legal Services event, and that will also be webcast. Our Law Society Awards ceremony is scheduled for May 27th, and I'd like to formally announce the award recipients. This year's Law Society medalists are Craig Carter, Professor Adam Dodek, Susan Eng, Faisal Joseph, John B. Laskin, Stuart Lavigueur, Patrick Shea, Chantel Tai. In addition, Paul Dre is the recipient of the William J. Simpson Distinguished Paralegal Award, and Paul LeBay is the recipient of the Lincoln Alexander Award, Kim Murray, the recipient of the Laura Legg Award. So congratulations to all recipients, and we look forward to the ceremony on May 27th. I'm also pleased to announce today 4 distinguished individuals who will be receiving the degree of Doctor of Laws honoris causa from the Law Society at our upcoming calls to the bar in this coming June. We have 4 recipients who will be receiving them. Julian Porter on June 23rd, Sheila Block on June 24th, Jean Taillet, June 26th, and James Stewart, June 26th in the afternoon. I think congratulations to this outstanding group of individuals. Next, bencher election. Voting has been open since April the 13th. Of the 47,396 eligible voters, we have, as of yesterday at 5 p.m., 9,167 having voted. Voting closes April the 30th at 5 p.m., and we encourage all lawyers to vote. It's one of the important and fundamental ways that lawyers can participate in our governance. It seems, in fact, just like yesterday, that this group of benchers gathered in this room 4 years ago in May. And over the course of the 4 years, we've made great strides in achieving the goals and priorities which were identified at the beginning of the term. The Articling Task Force and the Law Practice Program, regulatory reforms like the Model Code and national mobility, paralegal regulation, and particularly the change in legislation and governance that made all 5 elected paralegals elected as benchers, tribunal reform, and the transition to a more independent tribunal, access to justice in the implementation of TAG. All of these initiatives were done while maintaining a stable financial position for the Law Society. I'm very proud, as I'm sure you are, of all of our accomplishments, and I'd like to thank our Chief Executive Officer and senior management team and all the staff at the Law Society for their hard work and support. This will be the last convocation for many of our colleagues, and I'd like to acknowledge them today. Constance Backhouse, John Campion, Mary Louise Dixon, Larry Eustace, Peter Festeriga, Alan Gold, Jennifer Halagian, Susan Hare, Nick Pastina, Linda Rothstein, Mark Sandler, James Scarfone, Alan Silverstein, Joseph Sullivan, and Beth Symes. All of you have made very important contributions to the work of our committees, our tribunal, and have been valued members of Convocation. And on behalf of Convocation, I offer our heartfelt thanks and gratitude. I'd also like to thank Julian Porter and Judith Potter for their dedication and contributions to Convocation over the years as elected benchers. Both of them will become ex officio life benchers in the next bencher term. So again, thank you, everyone. On April the 8th, the Law Society, together with the Ontario Bar Association, the Advocate Society, the Ontario Paralegal Association, County and District Presidents Association, the Toronto Lawyers Association, the Criminal Lawyers Association, and the Family Lawyers Association hosted a reception to honor the Honorable Anne-Marie Boncalo, who is marking the end of her term as Chief Justice of the Ontario Court of Justice. Her career has been exemplary. She has been a true trailblazer, the first female assistant crown attorney in Peel Region in 1978, one of two appointed the first female judges of the Ontario Court in Peel Region in 1990, then appointed a regional senior judge in 2004, associate chief justice in 2005, and then chief justice in 2007. Her contributions have had a great impact on making the court more open, accessible, and modern. And again, I would like to formally acknowledge, on behalf of Convocation, Chief Justice Boncalo's outstanding contribution to public service and the administration of justice in Ontario. I'd also like to offer my congratulations to Associate Chief Justice of the Ontario Court, the Honourable Lise Maisonneuve, on her appointment as Chief Justice. She will succeed Chief Justice Boncalo and take office on May 3rd, 2015. Our annual general meeting is scheduled for May 13th. This meeting will take place at 5:15 in the Lamont Learning Centre. There has been one notice of motion filed for this meeting, and it's available on our website and will appear in the April 24th edition of the Ontario Reports. I'd like to remind everyone that a motion passed at the annual general meeting must be considered by Convocation within 6 months of the meeting, but it is not binding on Convocation. Also like to offer congratulations to bencher Paul Shabas, who was inducted as a fellow of the International Association of Trial Lawyers at its spring meeting in Santa Barbara on March 19th. Finally, we have new adjudicator appointments, and the Convocation already appointed the following lawyer licensees to the hearing division of the Law Society Tribunal for a 2-year term: Murray Chitra, Shane Hurt, Margaret Layton, and Sophie Martel. And now let's turn to the agenda. Okay. First is the consent agenda. Okay. Can I have a motion to approve the consent agenda? Okay, moved by John Campion, I guess seconded by Barbara Ritchie, I think. Next, we have the second, pardon? Oh, I'm sorry, we have to vote. Even though it's a consent agenda. All in favor?
The conference is no longer in lecture mode.
Any opposed? Okay. No, any opposed on the phone? No, thank you, passed.
The conference is in lecture mode.
Okay, and we'll now have the Secretary's report, and that will be offered by Barb Murchie.
Thank you, Treasurer.
It's found at tab 3, I believe.
It's a pretty straightforward amendment to Bylaw 3. As you will note, in a year in which the bencher election for lawyer benchers is held, Bylaw 3 provides that the close of nominations for the treasurer's election is the 4th Friday in May. the Law Society Act requires that an elected bencher be elected as treasurer. And in a case like happens this year, the convocation is in May, at which the new benchers take office. It comes after the fourth Friday in May, and therefore, under those circumstances, the newly elected benchers would not be eligible to stand for treasurer, or to vote for that matter as well. And the bylaw amendment is necessary as a result, and it will provide that the close of nominations is on the Friday immediately after the day on which the regular meeting of convocation is held in May. The motion is at tab 3.1, page 91 of board books, and it's self-evident. Okay, Treasurer, I move that this motion be adopted.
Okay, and I understand Ross Earnshaw is seconding it, is that
Yes.
correct? Okay, thank you. Any questions or comments in the room? Questions or comments from the phone? Oh, got
let
double
me,
duty here.
I'm new to this.
Okay, any questions or comments from the phone? Okay, if not, we'll call the motion. All in favor? Okay, any opposed?
The conference is in lecture mode.
Any opposed on the phone? Okay, pass. Next, we'll have the audit and finance report. Mr. Brett and Mr. Wardle, you've divided that up?
Yeah.
Okay.
Good morning, everybody. We have good news on the audit and finance front. So, the audit and finance report begins at board book at page 93. So, if you could go to page 93. So what we're going to do is I'm going to review the annual statements, and Peter Wardle is going to review the other matters. The motion before you is at board books at page 95, and in order to assist in following the remarks, if you could turn to the schedule of revenues and expenses that are on board books at page 125. So, just if you look at the bottom line there at line 14, you'll see that our budget had projected a deficit of about 2.4 million, and we've actually recorded a surplus of about 2.5 million. So that's a good piece of news. There are some issues that I think people should be aware of. When we look at our restricted funds, we're reporting a combined deficit of 18.5 million compared to a 1.3 million surplus in 2013. And the main reason for this significant deficit is the adverse claims experience in the lawyer compensation fund arising from two major alleged defalcations, which resulted in a provision for grants of 13 million and a reduction in the fund balance from 26 million to 16 million. The compensation fund describes a major defalcation as being over 35 claims arising from the conduct of one licensee in a single year, and the fund has had two of these major defalcations in 2014. Most of these claims are still being evaluated. In some instances, investigations are still ongoing. Based on the advice of the actuary, the fund balance remains sufficient to absorb additional potential exposure. The Compensation Fund Committee, the Professional Regulation Committee, Audit and Finance will continue to assess the impact of these claims. However, even after the adverse results for 2014, the Compensation Fund balance remains in compliance with the levels set out in our fund balance policy. So the issue here is we had a very large surplus in that fund, and the surplus is not quite what it once was. So let's go back to the day-to-day operating results. If you look at line 1, you can see that we were pretty close to budget in terms of our annual fees. Registration, the next line is the professional development competence, and you can see that we did better than budget. It continues to increase. For those courses that were previously free, there have been some decline in registration. The Law Foundation provided grants totaling $385,000 for the paralegal and lawyer licensing process. And this is going to be the last year we get that. We want to thank the Law Foundation for their contributions over the years, and we note that the Law Foundation has commenced financial support of some of the Society's access to justice initiatives. We come down and look at the expense categories. You can see that for the most part we did better than budget. If you look at line 17, under line 7, professional regulation tribunals and compliance, we tracked pretty close to budget with the exception of some excess spending and outside counsel and expert witnesses. If you go to some of the contingent liabilities, I won't take you to them, they're in board books at page 123, but note 17 notes that we have addressed some contingent liabilities as a resulting of potential cost awards against the Society, and there are at present time 3 matters which might lead to significant cost awards, and accordingly we've included that as a contingent liability. Professional development and competence expenses were under budget, primarily because of savings in the Pathway pilot project. That's line 8. If you go to line 9, you can see severance costs from the operational review exceeded budget, but we're hoping we're going to get some long-term savings from this. If you go to line 10, you'll see convocation policy and outreach is under budget, primarily because of less bench remuneration and expense than had been budgeted. The motion includes the approval for interfund transfers as noted in note 14, and simply in conclusion, the Society remains financially sound and is well placed for the future. We note that as a result of the operational review, we are making progress in terms of returning to a balanced budget. And I note that the approval of these statements mark the end of the business cycle and the end of our venture cycle. My co-chair, Wardle and I want to thank the Audit and Finance Committee, the auditor, Deloitte LLP, and the staff, and in particular, Rob Lapper, Wendy Teisel, Fred Grady, Brenda Albuquerque-Boutier, and Andrew Koss for all the help they provided us over years. So the motion is moved by me, seconded by Mr. Wardle, is that Convocation approve the draft audited annual financial statements for the Law Society for the financial year ending December 31st, 2014, including the transfers to and from the restricted funds which are set out in note 14 of the notes to the annual financial statements.
Thank you. Any comments or questions in the room?
The conference is no longer in lecture mode.
Any comments or questions from the phone? Easy ride, Mr. Brett.
You drone on long enough, get rid of that guy.
Okay, in that case, we'll call the vote. All in favor? Okay. Any opposed? On the phone, any opposed? Thank you very much. Motion
Treasurer,
carried.
Mr. Ward will be handling the balance of the matters on the audit finance agenda.
Okay, thank you.
As soon as I can open my iPad. Thank you, Treasurer. So the next matter for decision relates to our investment policy. And it's found in Board Books at page 126. So as you know, the Law Society has long-term investments which are managed by an outside investment manager and invested in the market. And essentially we have $78 million that's in investments, and they consist of three funds: the Errors and Emissions Fund, the Compensation Fund, and the General Fund, which is really our operating fund for the Society. And those funds are managed by an investment policy which has been developed by the Audit and Finance Committee and approved by Convocation from time to time. 85% of those funds are in fixed income instruments, and 15% are in Canadian equities. So if you think about that for a minute, it's being managed in a very, very conservative fashion. We need to make some minor changes to the investment policy this year, and if you look at page 127 of Board Books, you'll see the changes that are being proposed. And our manager, which is Foyston and Gordon, believes that this is an appropriate change to the investment policy, and that's supported by our consultant, Brian White of Aon Hewitt. So there's really two things that are going on, and if you look at paragraph 19, you'll see that this is our current investment policy with respect to our bond holdings. There are two things going on in the marketplace. First, there are less government bonds available generally to buy because provincial and federal governments are reducing their borrowing over time. And secondly, there's been a change in the corporate bond market as a result of some rating changes, and as a result, certain bonds that we would ordinarily purchase are now in the BBB category. They're still high quality bonds, but they're no longer rated at a AA or a AAA. They've been moved down in the rating category. So what our investment manager has recommended is that we change our asset mix for both Canada and provincial bonds and relax our target a little bit for corporate bonds, so that the target for BBB bonds will allow us to purchase up to a maximum of 18%. And that's found at paragraph 19. So the change really is from it's all in paragraph 19. The old policy is set out in the beginning of paragraph 19, and the new policy is set out at the end. If you go to the actual policy and just look through it for a second, it's set out in Board Books starting at page 131. And again, we're investing our $78 million in a very conservative fashion. We've been told by our manager that these changes, which are relatively minor, are not going to change the overall risk profile of the portfolio. If you, again, look through the investment policy, you can see, if you go to page 133 of Board Books, those are the funds that are being invested, the exception of cash, obviously. And then you'll see the various parameters set over the next few pages. The asset mix in paragraph 13, diversification. Our bond portfolio is being invested in short-term instruments. No more than 8% of each of the portfolios can be invested in the securities of one single issuer. And then you'll see at paragraph 19, that's the new investment policy with respect to bond purchases. So we are going to be looking as a committee at whether we should increase the equity percentage of the overall portfolio from 15% to some larger number, but we're not recommending anything in that regard at present. And again, our present structure for our long-term investments is $78 million, very conservative, not going to be affected significantly by this. So the motion is simply set out at, again, I lose this if I, page 126, it's that Convocation approve the updated investment policy. I'm moving the motion, it's seconded by our new Vice Chair, Ms. Elliott.
Any questions or comments? Mr. Warren?
The conference is no longer in lecture mode.
Any questions or comments from the phone? Okay, in that case, we'll call the vote. All in favor? Any opposed? Any opposed on the phone? Motion carried.
Thank you very much.
The conference is in
I'll move
lecture
on, Madam
mode.
Treasurer, to the next item for decision, which is at page 140 of Board Books. And this is that Convocation approve the continued retention of the investment manager, Foyston, Gordon and Payne, and the custodian, CIBC Mellon Global Security Services Company. So I'll just speak briefly to Foyston, Gordon and Payne. They've been our investment manager for some time, since 2003. We get regular reports from our consultant, Aon Hewitt, which really gives us an assessment of what Foyston Gordon is doing. Over the most recent 4-year period, our manager outperformed the benchmark by 1.1%. There's no real issues with Foyston's performance. We're happy with them. We met recently as a group with both Foyston and Aon Hewitt, and so there's no reason at this point in time to consider changing our manager. We have a custodian, obviously, for these funds, and again, there's no reason at this point in time to consider a change in custodian. So I'm making the motion, and again, it's seconded by Ms. Elliott.
Okay, thank you. Any questions or comments in the room? Questions or comments from the phone? I'll call this vote too. All in favor? Any opposed? Any opposed on the phone? Motion carried.
The
Thank you,
conference is
Treasurer.
no longer in lecture mode.
So the next matter that I have to deal with is a new banking resolution. This is found at page 217 of Board Books. This is a rather controversial matter, and I had thought perhaps I'd let Mr. Goldblatt deal with it.
I have my own, thank you.
However, it's really self-explanatory. I'm not going to take
In lecture mode.
the time of Convocation to go through it again. It's moved by me, seconded by Ms. Elliott.
Any questions or comments about check signing authority? Any questions or comments on the
The
phone?
conference is no longer in lecture mode.
Okay, hearing none, we'll call the vote on this. All in favor? Any opposed? Any opposed on the phone? Motion carried. Thank you, Mr.
Thank you
Warren.
very much,
In lecture
Treasurer.
mode.
And under our information items, I'm going to ask Ms. McGrath to deal with the Law Pro report, please.
Thank you, Treasurer. I appreciate this opportunity to provide an overview of LawPro's 2014 results. The results are more fully explained in LawPro's materials, found within the Audit and Finance Committee report, starting at page 247 on Board Books. LawPro posted 2014 results that have some good news for us. The financial markets performed well again in 2014, as in 2013, and LawPro reaped the benefits. LawPro realized net income before taxes of $17.1 million and comprehensive income, which includes the net income, of $18.8 million. Shareholders' equity, which represents the value of the bar's investment in LawPro, has increased by $18.8 million to a total of $2,008.6 million. On the expense side, general expenses in 2014 were $500,000 higher than 2013, but still $500,000 lower than budget. So LawPro ended the year with a general expense ratio of 18%, That is 8 cents of each premium dollar being spent on general expenses, well below the 27% that is more typical of comparable small insurance companies. That difference represents money in the pocket of LawPro's insurers. One way our regulators measure our financial strength is the minimum capital test, or MCT. At December 31st, 2014, LawPro's score was 251%, above the 220 to 230% score for which the company aims, and well above the supervisory target of 150%. Changes to the MCT calculation began to be phased in effective January 1st, 2015, and the full scope of the changes will come to bear over a 3-year period. A current calculation based on the new formula without phase-in results in an MCT score of 214%, acceptable but well below our preferred number. So it is critical that LawPro has the benefit of extra capital from 2 good year ends to help absorb the changes to the MCT. Having said that, LawPro will continue to monitor how our MCT calculation will be affected by the new rules and will take appropriate action over the phase-in period if necessary. These sound financial results allowed LawPro to handle the increasing number of insureds and maintained its base premium steady for the 5th year in a row at $3,350 for 2015. However, the number of new claims that are received continues on a high plateau. 2,572 claims in 2014. As in the past, real estate and litigation claims account for the bulk of the claims by both cost and count. We are seeing growing numbers of claims caused by poor time management, as well as failure to either know or apply the law and inadequate investigation. The increase in time management claims was driven by Rule 48 administrative dismissals. I should note that although there is a new administrative dismissal regime as of January 1st this year, there will still likely be some claims arriving at LawPro in 2015 from cases that were in the process of being administratively dismissed at the transition date. LawPro saw increases in the inadequate investigation error in several different areas of law, including real estate, plaintiff litigation, and wills and estates. Increases in the failure to know or apply the law were found in real estate, wills and estates, family, criminal, and employment law. Large claims, defined as claims with a value higher than $100,000, continue to exceed 200 per year. But not all the claims news is bad. The claims count per 1,000 lawyers was down, slightly, for the 2nd year in a row. There were 103 claims per 1,000 lawyers in 2014, down from 104 in 2013 and 108 in 2012. LawPro continues to be very successful in defending its insureds, where appropriate. In 2014, LawPro won 8 of 11 matters that the company took to trial and on which a decision was rendered. It was successful in 8 of 10 appeal decisions and won 16 of 22 summary judgment applications. As we have said before, the rule of thumb in the insurance industry is that if you aren't losing some, you are being too conservative in what you pursue in the courts. LawPro is also maintaining its strong record of successfully resolving claims on a highly cost-effective basis. About 43% of closed claims had no payment of any kind, indemnity or expense. Another 41% were closed with just an expense payment. In other words, only 16% of claims closed in 2014 had indemnity payments on them. LawPro maintained its commitment in 2014 to proactive risk management. Company staff delivered 65 presentations on risk management related topics to lawyers, paralegals, and law firm staff. In addition to publishing LawPro magazine, 4 digital newsletters covered specialized issues affecting sole and small firms, criminal law, litigation, and communication risks. A major focus in 2014 was rolling out the Cyber Liability Education Program. There have been 30 live presentations on this topic. To date, we have no claims under our new endorsement for cybercrime risk introduced in January 2014, although LawPro has received several claims that have had certain cyber aspects to the underlying facts. Clearly, education in this area is valuable. For the next 18 months, the main focus will be on helping civil litigators understand the changes to Rule 48 and the complex transition provisions. A variety of checklist tools will be released shortly. Looking ahead, what does all this mean for 2016 premiums? The LawPro board will start its work on the 2016 program offer next week, a task that continues until the start of September, so stay tuned. As you can see, providing good quality, cost-effective professional liability insurance to the Ontario Bar is a complex task. An ever-changing mix of claims, a complex regulatory system, and a potentially volatile investment market must be balanced with the needs and expectations of our insureds. These complexities are part of the reason, 20 years ago, the Law Society Task Force recommended moving the primary insurance program for its members to an independently operated insurance company. In the intervening 2 decades, LawPro has grown into a solid, professional, and admired company. I am proud to be its chair, and I am sure my fellow benchers who sit as LawPro directors would say that while it is a tremendous amount of work, it is both a great opportunity to learn and to serve. LawPro has just received its 15th A rating from AM Best, and that news adds to the pride we should all feel in LawPro. The full LawPro annual report is available online at lawpro.ca. It is now being produced exclusively in electronic format. I also encourage you to watch for the special Year in Review edition of LawPro magazine, which will provide much more detail on how the company met its mandate in 2014. That issue should be in your inbox in the next few weeks. Thank you for your attention. Either I or Ms. Waters, with your permission, Treasurer, will be happy to respond to your questions.
Thank you very much, Ms. McGrath. Any questions or comments on the LawPro report?
The conference is no longer in lecture mode.
Any questions or comments from the phone? Thank you very much.
The conference is in lecture mode.
We're going to just change the order slightly and go to tribunals next, please. Mr. Anand?
Thank you, Treasurer. There are 2 items beginning at page 442 of Board Books, tab 8.1, one for decision and one for information. The motion for decision is a housekeeping motion, and it arises from the fact that the tribunal, the Law Society Tribunal, will be moving during the week of August 10th to its new premises at 375 University. Where there will be 4 hearing rooms, offices, breakout rooms for panels and the parties. And we simply need to change the forms, which refer to 130 Queen Street West. So I hope I don't have to say too much more about that.
The conference is no longer in lecture mode.
We need a seconder, by the way.
Ms. Lieber will second.
Okay, Ms. Lieber. Okay. Any questions or comments from the phone? Okay, we'll call the motion. All in favor? Any opposed on the phone? Motion carries.
Treasurer, before we move to Mr. Wright's presentation, I just wanted to say a few words. We have
The
the
conference
move.
is in lecture mode.
We have the move on August 10th, as we just referred to. And we'll now have the first annual report of the first full-time Law Society adjudicator in Canada, the chair of what is now the Law Society Tribunal. Both of these initiatives are part of the evolution and enhancement of one of our most important functions as a regulator, the adjudication of complaints and other issues. Clearly that's been achieved and is being achieved with the invaluable assistance of Grace Nikowski, Sophia Sperdakos, the tribunal office. Many of the benchers who are not running this time have made a significant contribution to that tribunal. And it's difficult to overstate the contribution of three of those retiring benchers, Mr. Sandler, Ms. Rothstein, Mr. Gold, who along with Mr. Bannock have guided this evolution and have worked tirelessly to develop our jurisprudence and the processes of a cutting-edge tribunal. And so on your behalf, Convocation, I wanted to express the gratitude of all of us to all four of these benchers.
Thank you. Now, Mr. Wright.
Thank you. Good morning, Treasurer, and good morning, Convocation. I can't start without just following up from Mr. Annan's comments and emphasizing not only everything he's said about their contributions, whether it is Mr. Bannock's contributions in putting together the various processes early on in the tribunal office, Mr. Gold's guidance of many issues over his time as chair, Ms. Rothstein's assistance over the last year and a half as vice chair of the hearing division, in particular in helping us develop peer review processes and many other things. And of course, I have to make a special mention of Mr. Sandler, who has, in guiding the appeal division, helped develop a robust jurisprudence, a clear jurisprudence that guides us on many issues. And as Mr. Annan said, their contributions cannot be overstated. And I think in particular the development of what is now the appeal division is due to the force and influence of Mr. Sandler in particular. And just to add to that, a personal thanks, because over the last year and a half, without the four of them, I couldn't have developed the position that I have had and made the enhancements that I have had without them, and without, in addition, Mr. Anand, Ms. Leeper, and Madam Justice Doyle, who is now, who was the vice chair of the Tribunal Committee. And as this bencher term ends, I want to express my personal thanks and gratitude to all of them, and to all the adjudicators, all of whom we don't have time to name, who may not be returning as elected benchers or appointed benchers, but who have collectively made such a contribution to the work of the tribunal and who will be sorely missed. I want to turn to my annual report, which, as Mr. Annan mentioned, is the first annual report that was mandated by the report of 2012 that led to the enhancements in the tribunal that the chair would present an annual report to Convocation on the work of the tribunal. This report, as with all, I think, annual reports and this organization is being produced only in electronic format. It will be available on the tribunal website, and there will be a link from the Law Society annual report once that is issued. And I know I'm thanking many people, but I think it's important to give a special thanks to Grace Nikowski, Registrar and Senior Counsel in the Tribunal Office, who coordinated the work on this and did much of it in a wonderful fashion. And the Law Society's Communications Department, who, and in particular Sally Hewson, who laid out these beautiful graphics that you'll see in board books. And they have a busy load this time of year, and especially grateful for their work. So let me actually talk about some substance. I want to just highlight some of the principal issues that we highlight in the annual report. And the biggest event of 2014 at the Law Society Tribunal was the passage of Bill, or the implementation of Bill 111, the modernization of the Legal Profession Act that took effect on March 14th, and officially established the Law Society Tribunal. Together with that, we made a number of amendments to our rules and practice directions to implement that. We developed a new logo and visual identity for the tribunal, established a website, in particular, again, with the help of communications and my executive assistant, Vashti Ramsuk. And the new website contains a wealth of information about the tribunal that I think wasn't previously available to the public and to licensees, including in particular guides for self-represented parties that were worked on by Lisa Malia of the Tribunal Office, together with a working group led by Madam Justice Doyle. Our website has now been updated again in 2015, enhanced again, and it includes now various additional information, access to all orders. We're adding links to the reasons that go with every order that we've made that are searchable on that website. That enhances the transparency of the tribunal, and we continue to make enhancements to that website, which is can be found at www.lawsocietytribunal.ca, or in French, www.tribunaldubarreau.ca. Another significant part of the work of the tribunal this year was in defining our values and our expectations for members and for the tribunal as a whole. Following a session with the entire tribunal and all benchers, we established a core value statement, which is available on our website, defining 4 key core values for the Law Society Tribunal: fairness, quality, timeliness, and transparency. And all the work we've done throughout the year, and you see in the annual report, it's defined around those values, has been aimed at enhancing our ability to deliver for the public, for the profession, and for the parties before us on those values. We established a job description for adjudicators, which sets out the key requirements and expectations of all adjudicators, and established, with Convocation's approval, a self-evaluation process, which was mandated, a form of performance evaluation was mandated by the 2012 report, and since the end of 2014, I've conducted self-evaluation meetings with all of the venture adjudicators whose terms expire at the end of May. We've also worked on enhancing our process for the parties. We've revamped our scheduling system, which allows parties to know which dates their matters will be called, and I think enhances our ability to effectively use the time of adjudicators as well. We've allowed scheduling to occur at pre-hearing conferences, which has reduced the number of times parties have to come before the proceeding management conference if they are appearing before the tribunal. And we've put a particular emphasis on enhancing our ability to case manage and to assist the parties in working on settlements that may address some of the issues in the case through pre-hearings. We've had a dedicated group of adjudicators, small group of adjudicators, working on pre-hearings who meet regularly to discuss strategy and aim to enhance consistency on those issues. We also, although it hasn't rolled out yet, we've put a lot of effort in 2014 into improving our ability to use technology. Together with the Project Management Office of the Law Society, we are building a new case management system in the SharePoint system, and our hope is that that will be rolled out in 2015 and will lead to significant enhancements for the parties, for adjudicators, and for the effectiveness of hearings. Recruitment was another significant issue in 2014. We appointed several new public adjudicators, lay representatives, all of whom had adjudicative experience, and we commenced a recruitment process for new lawyer adjudicators as well. All of those adjudicators went through, or will go through, a 2-day training program, and as well as other onboarding experiences. Education of our existing adjudicators and new adjudicators has been an important part of our work, including programs on adjudication skills and the principles of evidence, among others. I want to highlight just a couple of the jurisprudential highlights of 2014. Mortgage fraud cases continued to be significant in both the hearing and appeal divisions in terms of cases being heard, although the number of new applications being filed with the tribunal alleging mortgage fraud was down somewhat. Issues of alleged failure to cooperate with the Law Society investigations and failure to cooperate or books and records continued to be prominent, and our summary hearing process continues to allow those issues to be addressed expeditiously and without significant expenses, we hope, for the parties. Our jurisprudence developed, in particular in the appeal division, on a couple of issues that I'd like to highlight. One is the definition and interpretation of what it means to be ungovernable, and the Schiffman and Ibagua cases, in particular in the appeal division, dealt with that. We had a significant appeal division decision on criminal law standards of practice, the BSANT decision. And early in the year, the Zinnis decision addressed the tribunal's approach to publication bans and to proceeding in the absence of the public. And those are just some of the many highlights of where the law was developed. Statistically, we closed more files in 2014 than we did in previous years. And fewer files came in, so our inventory has been reduced. 82% of our files are less than a year old, which I think speaks well. Our adjournments were down, and our number of reasons were up, which I think results and shows greater transparency to the public in terms of clearly explaining what we're doing when lawyers and paralegals come before us and why. I'd like to conclude by thanking all of you. This convocation chose in 2012 to put forward and put into place the model for an enhanced system of adjudication that we're in the process of implementing. I think a year and a half into that process, we're showing many enhancements thanks to the hard work of all of you, the hard work of all the adjudicators, and the hard work of the tribunal staff. And I think what we're doing is better serving the members of the legal and paralegal professions, the public, and the people of Ontario. So thank you very much.
Thank you very much, Mr. Wright. Any questions for Mr. Wright from the room? Comments? Any questions or comments on the phone?
Oh, sorry.
No longer in lecture mode.
Any comments or questions on the phone? Mr. Sandler.
The conference is in lecture mode.
I just wanted to take the opportunity to thank Mr. Nan, to thank Mr. Wright, to thank the Treasurer for a very kind comment, not only directed to me, but directed to those of us who are involved in the tribunal now for 3 terms or more. And I'm going to follow my comments today with written submissions after they're edited for content and format. But for the time being, I did want to express my gratitude as well to all of you. We are in a very different situation than many tribunals because you've had the generosity to allow me to come to Convocation and to explain to you in a way that judges of the Court of Appeal don't have to do, or judges of the Divisional Court, why I and others are respectfully of the view that you were wrong. And what I was going to say is that's really quite extraordinary on your part, that we can have that dialogue, ongoing dialogue, and I've never felt that you had to agree with the decision when it is different from that at the hearing panel, but you've always shown such generosity of spirit that it is very much appreciated. I can tell you the good news, which you already know, which is that the vast majority of cases do not require that kind of comment on my part. But what I've seen throughout my years as chair and most recently vice chair is a real dedication to get the job right. And I can tell you, and I am in a position to say this, that the quality of the hearings, the quality of the reasons that are being delivered now at large are superior in a very significant way to what I saw when I started the job some 10 years ago. So thank you all, and I'm very, very grateful in particular for the creation of a permanent chair. It was not only from my personal perspective a welcome development, but Mr. Wright has been superb in the position, if I may say so myself, and it's been great working with him. And the final thing is that I've had the opportunity over those years to work not only with the staff at the Tribunals Committee, but also the staff at the Tribunals Office. And for those of you who don't do regular administrative work, you won't know how extraordinary our staff is. Our clerks are without exception superb at what they do. They're led by Grace, who does a superb job as well. Lisa has been great assistance to all of us. Our editors are fabulous. And I have worked with a number of administrative tribunals, and I can tell you that the uniform quality of our staff is really something that is truly extraordinary and something we should be very, very proud of. So we've got way to go. That's why we've got the tribunal under the stewardship of Mr. Wright. There are improvements to be made. Sometimes I get frustrated because there are several controversial cases that are in the system, and without commenting on the merits of those cases, those are where the focus sometimes is directed by members of the public, and they don't see the day-to-day extraordinary work that's being done. But I wanted to take this opportunity in public to acknowledge that. So thank you very much.
Thank you, Mr. Sandler. We'll go back to our order and our agenda and move to the Equity and Aboriginal Issues Committee report. Mr. Shabas.
Thank you, Treasurer. I'm here to present motions on behalf of the Human Rights Monitoring Group. Requests for intervention, they can be found at tab 5.1 of board books. The first one relates to the death of the lawyer Alberto Nisman in Argentina. Many of you will be familiar with the sudden and somewhat unexplained death of one of the chief prosecutors in Argentina, and I don't think I need to go into the details of it. We are expressing concern, along with many other groups, about the independence and diligence with which there will be a proper investigation of Mr. Nisman's death. And the proposed letters and public statement are found at 5.1.1. The second one relates to the Philippines. We were approached, unfortunately too late, by an organization called Lawyers for Lawyers, asking to participate in what's called the Day of the Endangered Lawyer in the Philippines. And subsequent to that, we received other information from other human rights organizations, Amnesty International and others, to join a broader statement around the use of torture in the Philippines. That statement is beyond the mandate of the Human Rights Monitoring Group, which only addresses issues relating to members of the legal profession and judges. But consistent with their request, we are proposing that we issue a public statement around the treatment of lawyers in the Philippines, which is quite shocking. 41 lawyers and 18 judges have been killed in the Philippines since 2001, I believe. Virtually none of the perpetrators of those deaths has been brought to justice. Most of them appear to be police officers and members of the Army. So we are proposing that Convocation approve a public statement expressing our great concern about the situation in the Philippines, and that public statement can be found at tab 5.1.2. I'm obviously open to questions, but I would move that we approve those letters and public statements at 5.1.1 and 5.1.2, and I'd ask Ms. Go to second it.
Questions or comments? Mr. McDowell?
Thank you. I feel obliged to our departing colleague, Mr. Sullivan, to quibble over one of these. And that is the Nisman letter. There's a statement. I agree absolutely the letter should go because this is a deeply disturbing situation. But at the end of the third paragraph, there's a statement, according to reports, Alberto Nisman's ex-wife Sandra Arroyo Salgado recently commissioned an unofficial investigation. The findings of this investigation have ruled out theories of accident or suicide. That is not actually supported in the background material. There's a footnote to a publication about the Philippines. And I just think that we have to be careful not to overstep in all of this, and given that that appears to be a statement that is not actually supported in the background material and is based upon third-hand reports of an unofficial investigation, perhaps that should be excised or altered.
Any comments, Mr. Chavis?
Well, we can certainly go back and perhaps alter the findings of that occasion. To me, actually, I don't see a problem with this. This is the finding of what is an unofficial investigation.
Well, but how do we know that?
Well, you're right that perhaps all of the materials supporting that are not in this report. We should bring this to my attention sooner, but I think it's in the report from the Guardian that's footnoted. But if there's a difficulty with that, we can go back and confirm the accuracy of it. And if we can't confirm that, then I'm prepared to take it out.
Is that satisfactory, Mr. McDowell?
Yes.
Just want to make sure what you're asking for the record. So confirmation that we have the record for that would be satisfactory?
Well, I just think we have to be careful. If you're going to sign letters making factual statements based on clippings, then fair enough, but I think that we just have to be careful to make sure that it is sourced, because we don't want to diminish the value of what we're doing here.
No, absolutely, Mr. McDowell, and we will go back and confirm that. And if we remain in doubt, then we will take that out so that the treasurer isn't signing something that can't be backed up.
Okay, can we have a motion then subject to that qualification? Yes. Is that satisfactory to the seconder also? Yes. Okay. Mr. Guerrero, do you want to clarify?
I just need some wording for the amendment to the motion.
So I'd ask that we approve the letters subject to confirmation of the reference to the independent investigation by Mr. Nisman's ex-wife, and if that can't be confirmed, then we will remove that from the letter.
Any other questions or comments in the room? Any other questions or comments from the phone?
The conference is no longer in lecture mode.
Questions or comments? Okay, in that case, we'll have the vote on the motion as amended. Okay, all in favor? Okay. Any opposed? Any opposed on the phone? Motion carried.
The conference is in lecture mode.
I'm advised that our guests have arrived and who will be addressing us later. So I propose that we take the break now, move to the speakers after the break, and then continue with the equity report. Yes?
Treasurer, I'm not objecting to that, but I just wanted to say that there is a matter for information which I think might be of interest from the Human Rights Monitoring Group, which is that with your approval, because of the urgency of it, the Law Society joined a petition to the United Nations Working Group on Arbitrary Detention relating to the Saudi lawyer Walid Abu Khair, for whom we have twice previously intervened. And I just wanted to express our gratitude to you, Treasurer, for supporting that. As Convocation knows, in urgent cases, we don't bring interventions to Convocation, and I think that it was an important statement for us to take that position at the United Nations, so thank you for that.
Thank you. Okay, we'll have the morning break then, and when we reconvene, we'll have the speakers. Having completed the break, we are back, and I'd like now to introduce our guest speakers for the morning and welcome them. First, Michelle Hollins, QC. I'd like to welcome you and invite you to speak to us about your role and the work of the Canadian Bar Association. Ms. Hollins took office in August 2014. She is originally from Saskatchewan and now is a partner with Dunphy Best Bloxham LLP in Calgary. She has a varied civil and commercial litigation practice with a focus on employment law. So welcome, Michelle.
Madam Treasurer, ladies and gentlemen, je suis heureuse d'être ici parmi vous aujourd'hui. I want to thank you very much for the invitation to join you today. It means a great deal to me and to the Canadian Bar Association to have some time on your agenda to very briefly say hello and update you on some of the work of the CBA. Less familiar with your processes, but I can tell you that in Alberta, I have many friends and partners that serve as benchers in the Law Society of Alberta, and I am intimately familiar with the amount of work that goes on for the benches. I'm sure that it is that much or more for you. And so with a lot on your agenda and a lot on your plate, again, I want to emphasize how much we appreciate the opportunity to be here. I want to just very briefly tell you about two of the major CBA initiatives that I inherited, but which have continued to progress over the course of my term as president. The first is our Reaching Equal Justice initiative. So this began as a report titled Envisioning Equal Justice, was released, I guess it'll be 2 years ago in August. And so the CBA has worked generally in collaboration with all kinds of other organizations and people to begin to reach the shorter term objectives with a view to the longer term goals. There are 31 goals in that report that reach out for, I think, 16 years or longer. So it's a very comprehensive, long-ranging report on equal justice. And I think one of the things that I always try to emphasize in terms of the value of that work was really the fundamental premise of the work that was done on reaching equal justice was to begin from the perspective of the client. And of course, that is something with which you concern yourselves on a daily basis. And I think it was really important for us to begin that work from that perspective, rather than talking about it as our profession or our system. In fact, I'm trying myself to resist the temptation to call them my files, because they're not my files, they're my clients' files. And so some shift, I think, that premised that work and has made it very very important. We're at a stage now where we're concentrating on a portion of what we call facilitating everyday justice. And I'll just give you one example of a recent piece of work. We've got what we are calling legal health checks, and on the cba.org website, you can find these there. And they are designed for the public, they are very user-friendly, and they are essentially to help people realize when they have a legal problem, when they might not realize that they have a legal problem. Because one of the things that came out of the early research on reaching equal justice was that an overwhelming majority of people didn't recognize a legal problem as a legal problem. And so those legal health checks, we just added, I believe, 4 or 5 more of them and released them all in conjunction with Law Day. So I'd encourage you to take a look. The second thing, of course, is the futures work. And so some of you will be familiar with my predecessor, Fred Heaton. He was the president of the Canadian Bar Association before I, and he stayed on as the chair of the steering committee for the futures work. That report was released last August, and since that time, Fred has had more than 50 speaking presentations on the futures, invitations to present. And this is to law schools, to law firms, to other legal organizations. He's been to a number of universities in the States. So his speaking schedule, even in his past presidency, has rivaled mine. But it's been wonderful, I think, to see that we put our time and our resources into something that has clear value. And there's a huge appetite, as you are all aware, for discussion of some of the issues that were raised in the futures report. I know that ABS has been the subject of a lot of discussion in this jurisdiction, elsewhere as well, but I think that in this jurisdiction it has gathered a lot of attention, and we're actually really pleased about that. And the CBA is, I think, quite proud that we were able to do the work, not just on this, but on some other parts of the futures report that I'll talk about, to do the work on something like, looking at ABS, to do the research, and to introduce that as a subject for discussion. And so we appreciate the time that you and your constituents have put into that discussion. I know that Fred sometimes, I don't know what the right word is, but is sometimes a bit concerned about the fact that other parts of the futures work sometimes are overshadowed by the debate on ABS as only one of the pieces of work coming out of that report. And so if it's been a while since you looked at the futures report, maybe going back to take a look at, for example, the portion on legal education, which is now, I think, gaining some momentum in discussions around the country, certainly in the jurisdictions that I've been visiting, and of course will be of keen interest to you as the regulator, as will entity regulation, which again is something that, as I've traveled around and I've met with individual law societies, I know is very much a part of their discussion around the table. So, well, we, as I said, we're very proud of the product that we produced, and very delighted to be part of conversations that are now going on all over Canada, if not North America. As has been pointed out, and in fact just as recently as a week or two ago, this Law Society of Upper Canada regulates almost half the lawyers in the country. And so we would be foolish, of course, not to be paying keen attention to what happens in this jurisdiction with some of these things that are the subject of discussion. And so watch we will. And we thank you for continuing that conversation. Orlando De Silva, Mr. De Silva is here and is going to speak, and I don't want to steal any of his thunder, but Orlando and I do share one very important common priority, and that's been personal wellness. And so I will only mention here the national initiative done through the Lawyers Professional Assistance Conference in conjunction with the Mood Disorder Society of Canada and Bell Canada, is launching a web-based self-learning mental health program in August of this year. And the Law Society of Upper Canada was one of our major contributors to that program. And so I really want to give you my heartfelt thanks and appreciation for that support on behalf of the organization and on behalf of all of the people that we know need that assistance and will hopefully avail themselves of that. I know that this is an exciting time as you close in on your elections. I know that a number of you are sitting around this table as benchers for the last time. And so to those of you leaving and those of you in the election that is, as I said, in its final days, I want to wish everyone luck, but also, I think most importantly, to thank you very much for your service. As a lawyer, you know, working to provide services to my client, and as I said, someone who is intimately familiar with the amount of work that you do, I can't express enough on behalf of my association and myself how much we appreciate that. I commend your commitment to the public that we all serve. So thank you very much for your time.
I'd now like to invite Orlando Da Silva to address us. Mr. Da Silva has worked in both the private sector and now the public sector, and he's at Crown Law Office Civil at the Ministry of the Attorney General. He took office as president of the Ontario Bar Association in August of 2014, and thank you for joining us.
Thank you, Treasurer, Benchers, President Hollins, and fellow guests. I very much appreciate the opportunity to address Convocation this morning on behalf of the Ontario Bar Association. I had a friend who worked in New York, and during one of her many 90-hour weeks, her boss, by way of a compliment, told her, "I sleep at night because I know you don't." Now that's called comfort as a compliment, but it is an apt analogy for the role that our organizations together play in our justice system. We both aim for a society in which Ontarians can take justice for granted, a society where people count on being treated fairly, and where businesses are certain that they can have their agreements enforced, and where parents know that they can protect their children. The OBA and the Law Society belong to the small league of those who must be constantly vigilant, those who must work to make justice a reality, those who cannot take the justice system for granted so that the rest of society can. And the threats to justice are not always obvious or intentional. This month, as the legislature considered Ontario's Immigration Act, we originally faced a bill that contained a provision for warrantless entry to law firms, absolute liability penalty provisions, and explicit permission for a statutory decision maker to ignore the statute in determining applications, all in the context of decisions that are as fundamental to people's lives as any decision a government will make. Now, we worked with the government to rid the bill of largely unintentional threats to the bedrock of our justice system: solicitor-client privilege, the duty of fairness, and the rule of law. The OBA was grateful to be joined by the reasonable and credible voice of the Law Society on many of those issues. The inability to manage mental health issues is a threat to our justice system that we have been battling for generations. There are many moving parts in that complex puzzle, and we will continue to work on piecing them together. But one small step forward may well be a profession that is itself able to freely talk about mental health issues within its own ranks. The Ontario Bar Association's Opening Remarks initiative, launched in December, is designed to start that conversation, to destigmatize mental health challenges, to support lawyers and teach them the skills to avoid and cope with triggers that threaten their mental well-being. And as many of you know, I started the conversation with my own story. This isn't an issue you can lead from behind on. I have suffered from a condition called asthenia, which is a chronic low-grade depression that escalates every 4 or 5 years into a major depressive episode, which I've always suffered in solitude and silence and secrecy because of the stigma that would be visited upon me and the harm that may be visited upon my career in disclosing. In one very dark day in 2008, I came close to dying from an intentional and quite massive overdose of prescription medication. I was hospitalized voluntarily for 3 months while I underwent a dozen changes in medications that failed, and then endured 13 electroconvulsive shock treatments, which were designed to change the telemetry of the brain. I was away from work, and my colleagues thought that my family thought I was at work during this time and too busy to visit. Work thought I was with my family until I told them that, you know, I had a health issue, but I said it was a physical thing. I didn't want them to know. So it is a secret that I had kept from my family and my closest friends, my employer, until August 2014. I became president of the OBA and thought that this was one opportunity to use that platform to talk about these issues. And until the profession is comfortable telling and hearing stories like mine, until the profession is comfortable knowing where people like me have been, and knowing it does not diminish our value, our strength, our skill as lawyers, parents, and friends. Until then, vulnerable people whose mental health issues bring them into our justice system, or whose issues are triggered by the stresses they find there, will not be able to take legal representation or justice for granted. I am hopeful, based on the fact that our Mindful Lawyer series, part of the Opening Remarks program, has attracted over 1,000 registrations. We expect it will be 1,200 by the end of the program in June, and that's for 6 modules. And I am very delighted that the Law Society has joined the conversation, and I'm looking forward to joining you at your May 6th event called Fostering Wellness, a discussion of mental health in the legal profession. We are ourselves hosting a summit on mental health involving all professions willing to participate on May the 22nd. Finally, as we vigilantly protect the cornerstone of Canadian democracy, I am proud to see our democracy is strong. The Bencher election has been characterized by robust and diverse participation, productive debate, and tasteful campaigns. Our OBA Bencher initiative is designed to encourage candidacy and to provide support to our member candidates, including many of you here today. But it also has given us a chance to interact with our membership in a positive and refreshing way. Thank you to all of the benchers here. You have safeguarded the public, the reputation of the profession, and the effectiveness of our self-government. While it is somewhat ironic from where you sit, the healthy competition for these chairs is a tribute to you. If people are knocking on the door to get in, it's because you have kept the house in good repair. I sincerely congratulate you, and you should be genuinely proud. Thank you for the invitation today, and thank you for your 4 years or more of sleepless nights.
Thank you very much, Mr. De Silva. As I indicated earlier, Ms. Hollins and Mr. De Silva will be joining us at lunch, along with Elizabeth Hall, who is sitting beside Mr. De Silva, who is the Director of Policy and Public Affairs at the OBA. So I look forward to talking with you further. And feel free to either stay or depart as it suits you right now. We still have a fair bit to do in public, and then at the end of the morning we'll be moving into our in-camera sessions. So the feel free to depart was aimed at the speakers, not everyone else. Mr. Faulkner?
Yes, through you, Madam Treasurer, as a co-chair of Equity and Aboriginal Issues Committee and as a bencher who has long believed the issues around mental health deserve our not only ongoing attention but more concentrated, more organized attention. I thank the speakers, and in particular I thank and acknowledge Mr. De Silva's courage. His sincerity, his ability to speak to issues that personally involve him, but at the same time show a level of professionalism that gives us all hope. I say that that kind of courageous submission is exactly what we need to improve our understanding of mental health issues and to do better. Thank you.
You're here. Thank you very much, Mr. Faulkner. Before we return to the equity agenda, I would like to offer any clarification that is required on the motion that is before the annual general meeting. As I stated earlier this morning, the motion is, if passed, is advisory only. It requires Convocation to address it. That is all. The motion itself is not put forward by the Law Society or any bencher. The motion comes from a member of the public, and it should not be described as a Law Society initiative. If there's any further clarification that's needed, I'm happy to provide it. And now, moving back to our agenda, I'd like to call on Susan Hare to deal with our Aboriginal strategy.
Thank you, Madam Treasurer. Ani nangosa gashe Nadeshnakas. Makwadodem Ninwa Chigim Shkunaganing. My Ojibwe name means Mother of Little Stars. I am from the Bear Clan, and I'm from the Chigim First Nation. I want to just begin briefly by advising you that this little necklace I'm wearing was made by my 10-year-old granddaughter, Weshka, who told me, when she gave it to me, she says, "You can wear this if you ever want to look good someday."
You look great.
Looking good.
Thank you. This is, today is my last convocation. I'm one of the benchers who will be running again. I am very thankful for the opportunity to represent the Northeast region of Ontario and also to contribute to the governance of the Law Society over the last 8 years. Today I have been asked to provide an update on the renewal process for the Aboriginal Initiative strategy going forward, and also to share my thoughts about this. When I first ran for election, my first time, my opening line was, "I am an Ojibwe woman." And then I further went on to state that my first fee for legal services was fish pie. I was elected. My second election, I wore eagle feather in my hair. And fortunately, I was elected again. And for someone who's Aboriginal in Ontario, I think that it's a very positive, the most positive reflection on the Aboriginal lawyers who may have voted for me and on the profession as a whole. In my talking about the renewal, I think we have to also reflect a little bit on the past. And I want to recognize, and I hope he's still on the line, the work of former Treasurer Harvey Strasberg, who had the courage to recognize the inequity and struggles of First Nations bar admission students in the early 1990s by assuring them with his signature that they have a place in the Law Society of Ontario. This was done amidst much troublesome publicity for the Law Society and probably amidst a lot of soul searching within the Law Society. But Harvey, with his courage and leadership, he resolved the issue. For this act of courage and leadership, Harvey Strasberg, for the Law Society, was given an eagle feather, which sits at Convocation table. Also arising out of his actions, the Aboriginal Initiatives Council position was established, and Marisha Roman holds that position today. And I wasn't here at the time, but I've heard of the persuasion exhibited by Heather Ross, among other benchers, in working to establish the Equity and Aboriginal Issues Committee as a standing committee of Convocation. To include Aboriginal people in this integral way is foresight, pure and simple. And it's also a sign of reconciliation. And after this convocation, approved the Aboriginal Vision and Strategy in October 2014, unreservedly, further actions were able to continue. And when I presented the Aboriginal Vision and Strategy in October 2014, I asked all of you at that time to step into my canoe, and you did. One of the first actions that began the process was the Treasurer met with the Aboriginal leadership in Ontario at the end of November. And it was explained to the Aboriginal leadership at that time that the Aboriginal Vision and Strategy would be two-pronged. First, we would continue to consult and respond to the needs of Aboriginal lawyers and paralegals in Ontario. But secondly, we would reach out directly to the Aboriginal communities through the First Nation leadership. So in early April, a few weeks ago, I traveled to North Bay and the Nipissing First Nation along with the Treasurer, Grant Wedge and Marisha Roman. And this was historic because at no other time has a Treasurer of the Law Society in its 218 years visited a First Nation in Ontario. Surely about time. In the morning, we met with Grand Council Chief Patrick Widose Midabi of the Union of Ontario Indians. And the Union of Ontario Indians is the Secretariat for the Anishinaabe Nation of Ontario. And the Anishinaabe Nation is approximately 55,000 citizens in 39 First Nations across central Ontario. The Grand Chief took 4 hours out of his time, out of his day, to explain the work that the Union does to serve its many citizens. He also discussed a consultation process for its self-governance building process. And he advised that the consultation, of course, includes the elders, the women, and the youth councils. Lawyers Fred Bellafield and Jenny Rastool in the Union's legal department, with support from paralegal Sarah Gannon, also was a part of the meeting. The legal issues that they described comprised a very broad-ranging area, from self-governance, which they call the restoration of jurisdiction for the many First Nations, conflict resolution, involving Anishinaabe citizens and also band councils. It's developing a citizenship law and is implementing the Anishinaabe matrimonial property law, which protects property interests of Anishinaabe people following breakdown of marital relationships on reserve. Because we had requested the meeting to be able to hear from the union about their current issues and initiatives related to access to justice, we followed their lead on the meeting agenda. Their questions were far-ranging and included issues relating to the appointment or lack of appointment of Aboriginal judges and justices of the peace in Ontario, as well as the availability of articling positions for Aboriginal people and the complaints process. The Treasurer responded that the Law Society did not have authority on some specific issues they raised, such as the appointment of judges, but rather had influence. And so we worked through their 6 main areas of interest in this way. At the end of the meeting with Grand Chief Midabi, we exchanged gifts and made plans to meet again. The Anishinaabe Nation is also going through an election this June. Their election is traditional. The Grand Chief is selected by having nominees stand in a large room, and the people who, the chiefs, the delegates who support him stand directly behind him. It's very open and transparent. What stands out for me though from the meeting, besides the issues we discussed, which were very important and educational, was how valuable it was to meet in person. I wished actually that more members of Convocation could have came with us. The Treasurer mentioned the Law Society's practice of using external advisory groups and how we are developing options for a new way to engage First Nation, Inuit and Métis and Inuit lawyers and paralegals in Ontario. But she also said that no formal structure was required to govern communication between the Union and the Law Society. She made herself available. It was also clear that the priority of the Union is now on its restoration of jurisdiction or self-governance initiatives. The Anishinaabe Nation is putting in place the infrastructure for dealing with issues of child welfare, conflict resolution, and citizenship status. The Law Society has an opportunity to support these initiatives through education, CPD, or otherwise, and thereby support the sustainability of the Anishinaabe Nation. The Nipissing First Nation was our second stop, and the Nipissing First Nation stretches from North Bay to Sturgeon Falls along Lake Nipissing. It's beautiful. There's 9 separate communities within the First Nation, one of which is Mosquito Creek. And Mosquito Creek exists off the grid. Nipissing First Nation, it was instructive to attend Nipissing First Nation as one of the first places the Law Society is going, because they are at a stage of development in law which a lot of First Nations are not quite at yet. They have undertaken to opt out of the Indian Act land provisions through the First Nations Lands Management Act. And that process is to develop an overall code and then to have bylaws underneath that. So Nipissing First Nation has numerous laws regarding matrimonial real property, commercial fishing, subdivision planning, anything that's related to land. And one of the unique problems they're facing is enforcement, because the police agreements in Ontario, even with the Aboriginal police forces, commit them to sign that they will only uphold provincial and federal laws. They do not mention First Nation laws, though these may be enacted through law. So there was a discussion where the First Nation was not so concerned about that aspect. They were, in terms of resolution, they were concerned on developing methods of enforcement that were Aboriginal. So it'll be interesting to follow that situation. As well, they talked about the lawyers in the area. They seem to be quite pleased with the lawyers in the area. They said they've made themselves educated in terms of when people have a matrimonial real property issue, for example, on reserve, they might own property off reserve as well. They have in the past had to take their large land code, the matrimonial real property law, the letter from the minister authorizing all of these things. They'd have to take these things to court to prove that what they were doing was legitimate and under law. But they seem to feel at this point that the lawyers in the area have stepped up and learned, and they are able to advocate somewhat better these days. So the trip to North Bay highlighted the benefits of going out to meet with our stakeholders in their territory. And I'm confident that the Treasurer will continue to attend these meetings, to plan these meetings and attend. It was very important for her to be there. Building on the integration of the feathers and the smudging ceremony into the convocation process, these meetings have given me added confidence that the Law Society is on the right path as it continues and renews its Aboriginal initiative strategy. So in terms of looking ahead, I want to leave you with some thoughts that highlight my experience over the last 8 years and where I believe that the Law Society can continue to honor its vision statement and contribute to the broader reconciliation process. First of all, the eagle feathers and the ceremonies we have already introduced to Convocation and to the call to the bar ceremonies. These are not mere symbols. These are tools for building capacity within the Law Society and should continue to be used as tools. I have described that renewal strategy as being transparent, respectful, proactive, and competent. And as we move towards reconciliation, the broader idea of reconciliation, we need to pay attention to our past relationships with lawyers, paralegals, and other external stakeholders, and acting the way we committed to through the vision to repair past relationships and set the groundwork for positive future relationships. This is about reconciliation. This is about what Harvey Strasberg did in the early 90s. This is about accepting the eagle feathers through former Treasurer Tom Conway, through the proper ceremony we held in the grounds outside of Law Society. This is what this is about, and it's very important because, in my view, the biggest impediment to reconciliation in Ontario between Aboriginal people and society at large is that Native people have almost no trust in the justice system. Whether it's criminal or civil, there's no trust. And to build that trust, we must reconcile with each other. We must rebuild that relationship. And as lawyers who are the most prominent players in that process, in my view, we have a large responsibility. So the real work, of course, of reconciliation will be in the future. I believe we're taking part in the Truth and Reconciliation events coming up shortly here in Toronto. And as we commit to engaging not only lawyers and paralegals, but also the leadership and citizens, we need to be mindful, of course, of the language we use. That is why when I first ran for bencher, I said who I was. I'm an Ojibwe woman. I didn't say I'm an Aboriginal woman. I'm a First Nations woman. I said I'm an Ojibwe woman. And the real role of symbols and ceremony carry us forward. If we think back to what happened when we brought the feathers here, you'll remember that Treasurer Conway, former Treasurer Conway, prepared benchers for Convocation in September 2013. We received briefing notes. We received instructions about how to smudge. Wasana says shared some of the teachings of the feathers with us. Diane Kelly, the daughter and lawyer of Grand Chief Peter Kelly, who initially gave us the feathers, spoke about how the feathers came to be here. And she said she was happy. And she said that her father would have been happy too to know that the feathers were finally being used properly. The other item that's out there and that hasn't been recognized and has to be recognized in the future is the wampum belt. After our meeting, as I mentioned, in Nipissing, we exchanged gifts at the union offices and we took a tour of the complex. Along the way, we saw posters for a teacher's kit called "We Are All Treaty People." The Union of Ontario Indians has developed a curriculum for grades 1 to 8 students, and it includes a Lego wampum kit belt. The kit represents one of the 2 wampum belts presented by the Crown Representative Sir William Johnson to the 2,500 First Nation chiefs and headmen who assembled in Niagara when the Treaty of Niagara was negotiated and accepted in 1764 by both parties. The Lego wampum belt is an education tool, and it recreates the Great Covenant chain with the year 1764 on it. So as I thought about the Lego kit, I also thought about the other tool that we have here at the Law Society, which is the wampum belt that was also presented to us. And that was gifted to the Law Society in October 1998 by Chief Mike Mitchell of Akwesasne. It remains under glass outside the Convocation room. While it remains there, it will stay as a symbol to us as opposed to a tool for enforcing and enhancing our understanding. Chief Mike Mitchell is alive. He is still the chief at Akwesasne. So we have an opportunity to open the door to understanding the history of our relationship to First Nations, Métis, and Inuit people. We can be proactive. As Justice Sinclair says from the Truth and Reconciliation Commission, reconciliation is an opportunity for everyone to see that change is needed on both sides and that common ground must be found. We are, after all, talking about forging a new relationship. And both sides have to have a say in how that relationship develops, or it isn't going to be new. The round table with the Aboriginal lawyers and paralegals we had last June must continue. And it should be at least an annual event. The wampum belt must be realized by Convocation over time. And the strategy that Convocation approved, of course, will go forward. But as my term is ending, it is up to the new bench to decide what tools it will need to forge ahead in regards to relationships with the First Nations, Inuit, and Métis people of Ontario. I spoke about former Treasurer Tom Conway. I think the first conversation I had with him was about moose meat, and there's some moose meat outside. I thank former Treasurer Conway and the excellent Diana Miles for making the certified specialist in Aboriginal law a reality, assumed to be a reality at the Law Society. I commend as well Jose Bouchard, Marisha Roman, and Grant Wedge. Mr. Wedge gives guidance, experienced guidance. Marisha gives quiet strength and collaboration. and Jose gives continuing stability. And I thank them for that. I just want you to know that the moose meat some of you ate this morning the moose was shot by my son in our traditional territory, Tom. He also made the sausages himself. So anybody that gets him as a husband is pretty lucky. So before I leave, I want to leave you with, I want to teach you another word of Ojibwe, if you don't mind. Okay, so all together first we say ba, ba, ma, ma, pi, pi, ba, ma, pi. That means till I see you again.
Miigwech, his hair, and I think you can assure your granddaughter you've never looked better. Thank you also for the contribution of the excellent moose sausage. I think I had more than my share, it's so good. And please express our appreciation to your son for that contribution too, and you're getting it here. So again, thank you for that. Importantly though, I do want to express on behalf of Convocation again the gratitude for the great contribution you have made in sharing your knowledge, your culture, your traditions, educating us in them, helping us understand how important it is to listen and learn and to reach out to people and then to understand their needs for access to justice. And that is very much the path that I think we want to be on and we're trying to be on, and you've helped us advance that vision and advance reconciliation. So thank you again.
Thank you.
And next on the Equity and Aboriginal Issues Committee list, we have a status report from Ms. Leeper and Mr. Anand on the challenges faced by racialized licensees working group.
Madam Treasurer, Convocation, I will never forget the last Convocation of the Mother of Gold Star, because it's the day I first ate moose meat. Thank you. Members, the challenges report released by Convocation last fall has been the subject of much consultation, as you know. We are pleased to report today to you that not only has there been widespread participation in these consultations, but by way of interim report, we can say with confidence that the profession has embraced the opportunity to discuss the issues and debate policy solutions for the challenges that were first identified last fall in the report. So today you have before you at page 347 of board books our interim report on these discussions. The working group plans to work on policy options over the next few months and return in the fall with some of those recommendations of Convocation. Mr. Anand and I have divided up our presentation this morning. I'm going to start with the arc of the consultations, try to provide a bird's eye view of some of the themes that have developed, and Mr. Anand will speak to the informative details. So on to the process. There was widespread participation and, tellingly, a lot of gratitude that the Law Society went out to listen to people. It's significant, I think, in an institution like this, how much people value the chance to talk to us on their turf, in their ground, in their communities, in their places. And we heard that from Newmarket to Bay Street and from Thunder Bay to Windsor. So we reached out across the province geographically. We spoke to a cross-section of lawyers and paralegals. Over 1,000 licensees have contributed to this consultation. You'll see at page 3 of our report, that's 351 of board books, there's a list that takes up almost the whole page of the interested organizations who either participated, met with us, or sent in written submissions, or did all three. It's, we feel as if we have covered a lot of ground. We also met with members of Legal Leaders for Diversity, the law firm Diversity and Inclusion Network, managing partners of the large firms who participate in that network, faculty committees, paralegals and their associations. Most of our meetings were in English, but we did conduct 2 in French. And we received many thoughtful and detailed written submissions, which you can also find via the link at page 353 of Board Books, and I commend them to you. The working group members who have been part of this group since 2012 turned out, they traveled, and benchers in the regions where we were having the meetings also came to those meetings. Again, that's something that cannot be underestimated. 2 of the sessions based here in Toronto at the Law Society and the Lamont Learning Center were also webcast to extend the reach of the consultation, and they were well attended. A complete list of everything, the dates, participants, and the places and summaries, all of this is found at 5.2.2.1, which begins at 363 of Board Books. And I must say that this document is but one of many examples of comprehensive and excellent work done by the staff to support this working group. So a few high-level themes. We have seen what I would call virtual consensus on 3 critical points. First, the findings of the consultation paper have been accepted as reflective of the realities faced by many members of our profession. There has not been pushback on the findings. Second, there appears to be consensus that there is a role for the regulator to play in addressing these challenges. We've heard this across Ontario from sole practitioners to the managing partners of the very largest and international firms that are based here in Toronto. What will our role be is something that the working group will be discussing in detail and trying to put real policy choices forward to Convocation. We have to think about a role that some have described as a facilitator, as a leader, as a source of recognition for best practices, as a catalyst, as a connector of mentors and mentees, as an educator and an accelerator of self-assessment. There has also been significant interest in our capacity for data collection. And as you will hear coming up in another report, the number of licensees prepared to provide us data in a very confidential and rigorous way is increasing and giving us very reliable data on who we are as a profession. I must note, and with thanks to Akua Kwanzaa, who was one of our staff supports, directed me to a recent edition of the Fordham Law Review 2015, issue 5. There's a report on a colloquium on diversity in the legal profession that's quite excellent. One of the papers we've circulated to the working group. But in that paper, there's some recognition that the efforts undertaken by the Law Society of England and Wales has been based on 20 years of research, yet they describe their progress as, quote, achingly slow. This reflects the fact that this is a complex set of issues. And in their world, the solicitors see the Law Society, I'm quoting now just from the end of the article, which you can all have access to. Solicitors see the Law Society as a source of advice that they do not expect to be criticized publicly. And while many want to know what their competitors are doing, few are willing to talk about their own experiences, good and bad. As a result, the Society sees its role here as a critical friend. I don't know if we're going to land on being the critical friend, but there certainly is a lot of research and thought given to this issue, and we are not alone as a jurisdiction that feels that it's time to try to do something meaningful and perhaps to try to transcend output and move to outcome. However, we have heard that the profession is ready, that students, clients, and the community have expectations around diversity and inclusion, and many of the large firms belong to the Diversity and Inclusion Network. They have begun to collect data, and they have begun to incorporate unconscious bias training into their recruitment efforts, and they're thinking about pipeline programs. Overall, I would say to you, we have heard the language of opportunity rather than the language of grievance. And as quoted in our consultation in Toronto from one of the lawyers who attended, perhaps we are at an inflection point. We see an appetite for culture shift, an awareness of the business imperatives and the cultural and relational imperatives. And we see the increasing diversity across the profession, as well as the willingness of our licensees to self-identify to help us understand where we're going. I will close this part of the interim report with these acknowledgements. This has been a true team effort, as you've heard. The working group, the dedicated and indefatigable staff work from José Bouchard, Akua Kwanzaa, Jennifer Rubel, and Céline Massaroni. Our home committee, the Equity and Advisory Committee, the participation of the benchers at large, the profession, the organizations, LFDIN, managing partners, legal leaders for diversity, and managing partners who are involved with recruitment. Now I wish to welcome back my co-chair, Raja Nand, and turn the floor over to him for a few of the details.
Thank you very much, Ms. Leeper. And building upon the three themes that Ms. Leeper spoke of, I want to dig down a little bit more deeply into some of the details of the information and the views that we received during the written and oral consultations and the open meetings. I think it's fair to say that the submissions put forward fell by and large within the broad categories that we had set out in the consultation paper, which was gratifying in the sense that there was no sort of pushback on the basis that this is not an area that you shouldn't even be discussing, and there were no sort of areas that we had drastically missed in the course of our discussion, but there was lots of conflicting and helpful input from groups and a lot of individuals, both orally and in writing. So the first area that we talked about was enhancing the internal capacity of organizations, that is law firms and other legal organizations, and we asked the questions: how should the Law Society act as a catalyst for the establishment of diversity programs within firms, and why? What is the preferred model for the collection of firm demographic data, and why? And how could the Law Society work with in-house legal departments to develop model contract compliance programs, that is where suppliers had to justify something in relation to their diversity or equity characteristics or policies, for in-house legal departments to retain firms. There was significant support for the creation of diversity programs for the recruitment, retention, and advancement of racialized licensees in firms and other legal organizations. A number of participants supported the creation of a diversity project modeled on the Law Society's Justicia project in the area of retention of women. Participants were divided on whether diversity programs should be mandatory or voluntary. Participants outside of the GTA in small firms saw the value of voluntary programs because small firms might lack the resources to implement mandatory programs. Participants in favor of mandatory programs argue that mandatory programs create stronger awareness of equity and diversity issues. And some participants believe that at the very least the Law Society should require firms and legal organizations to have equity and diversity policies in place. Indeed, one of the large firms commented in its submission that human rights law requires that legal organizations have a policy and complaints procedure in place. Some participants supported the proposal that firms complete a self-assessment about their diversity performance, which would include more than an analysis of demographic data. The majority of those interested in this idea suggested that the self-assessment should be voluntary. However, there was talk of the Law Society providing incentives for firms to engage in the process, and indeed the Law Society preparing, as it already has in other areas through the Equity Department, self-assessment templates and tools, which, as I say, there are analogous documents already, to provide to law firms and legal organizations from a centralized source, that is the Law Society. The issue of demographic data and tracking has always been a matter of discussion since the Employment Equity Act, at least federally 30 years ago. But I think it's fair to say that there was a broad consensus that to ensure change and to track real progress, one needs some measurable yardsticks. That doesn't answer the question as to how to do that, and there were several questions that we put forward and that we got views on. Should it be done or not? As I suggested, I think there was largely a consensus on that. Should it be mandatory or voluntary that demographic information be collected? Should it be public or confidential? In other words, the results. And fourthly, how to do it in terms of the nuts and bolts, broadly speaking, of how, which is itself a sensitive and difficult issue. So there's a broad range of views on these issues. In terms of the how, the majority of participants, including those in small firms and outside Toronto, were in favor of the Law Society collecting demographic data. And many suggested the Law Society could use the data collected in the annual report to provide firms and legal organizations with their individual demographic data. Now, as we'll be hearing from Mr. Faulkner, there's a great deal of aggregate demographic data that has been collected because of the high participation rates on the lawyer's annual and paralegal annual report from an aggregate basis, so indeed much of what was commented on is being provided, but aggregate and public, and not through communication directly with the law firms. There was a view from many that in order to create change, the demographic information for each firm should be publicly available. There were issues raised as to if the firms and legal organizations were collecting this data, the Law Society should ensure that there are processes in place for self-identification. Those who advocated for voluntary data collection have noted that a number of large firms are already engaged in demographic data collection and inclusion surveys. And the view is put forward that if the Law Society mandated it, it could indeed have an unintended negative effect in impeding or stalling or diverting already underway processes. Contract compliance, that is where organizations seeking legal services would require information as to equity policies and perhaps makeup and perhaps representation information within the firms that are providing those legal services. And we know about the Bank of Montreal having endorsed and implemented this on a widespread basis. And the work of the Legal Leaders for Diversity, which are large corporations which have been spurring on large firms to be providing, to be justifying in equity and diversity terms why large corporations should be retaining their legal services. On the issues of demographic surveys and contract compliance, there was an ongoing debate about essentially the carrot and the stick of rewards for recognition, as has been done, for example, in the pro bono area, versus mandatory requirements. And there was the ongoing issue of small firms and large firms and whether there could be rules that were applicable to all. The second area that was, large area that was discussed was mentoring, advisory services, and networking. We asked questions about the preferred mentoring and advisory services and preferred networking models. We received a lot of input on that. As we know, there's a mentoring task force which is going to be reporting on status today as well, and so I won't spend a lot of time on this, except to say that again, this was an area on which there was a broad consensus. I attended some 19 of these sessions, and I don't recall ever hearing anyone say that we should do anything but encourage or mandate mentoring and networking opportunities for racialized licensees, paralegals, and lawyers, leave aside for the rest of the membership of the Law Society. So there was a good deal of discussion about sponsors, champions, whether they should be racialized, non-racialized, what are the options, and various mentorship models, one-on-one, virtual mentoring through the internet, group mentoring, and several others, which I think will be discussed as well further on. There was a suggestion that the Law Society could have licensees note on the annual report if they're willing to act as mentors in order to further assist in creating a mentor roster. Participants outside the GTA highlighted specific issues relating to mentoring in their regions and the fact that most of the affinity groups, the equity-seeking groups, that don't operate outside the GTA to the same extent, which limits access to association-based mentorship programs. Enhancing cultural competence in the profession. There was, you'll recall that there was a question put, how could the Law Society enhance the profession's cultural competence through its CPD programs? And again, there was a broad consensus that greater awareness, knowledge, training in consciousness of unintended bias and indeed of these issues, which we're hoping this working group and the Law Society's commitment to this has assisted in, are good things, and they are fundamentally accepted by all. With respect to the CPD programs, most participants, I think, suggested that the Law Society could make issues of cultural competence and recruiting in a bias-free way part of the professional responsibility and practice program for incoming lawyers, and for perhaps an hour of the 3 that are allocated to professionalism. Some would say all of them, some would say more than the 3 should be allocated to equality issues, given their place in our society and in our law society and in our profession. So I think there was broad consensus that equity begins with an education, for those who have, through practice and through their involvement in law firms and legal organizations, have not been as involved as others. A participant suggested that the Law Society could use its seat on the Federation of Law Societies to encourage the inclusion of cultural competency and diversity awareness as a part of the core law school curriculum. Looking at the president of the Federation, as I say that. Discrimination and the role of the complaints process. The issue, the question is, how should the Law Society best ensure that complaints of discrimination are brought to its attention? That is, complaints within the profession, between professionals and clients, between professionals and staff, are brought to its attention and effectively addressed. And we know that there have been very few complaints of this kind which have reached the Law Society tribunal. And one of the underlying issues that was recognized and put forward is the chilling effect, and the fact that it might not be a career-enhancing move to be making a complaint of discrimination against one's firm or one's legal organization. So the question was, how do we get at those issues where it's appropriate to do so? And there were suggestions about updating the rules of professional conduct. Clearly they cover human rights. They could address systemic discrimination and subtle forms of discrimination in a more overt way. Publicity, public education are, again, areas that the Law Society has an ongoing role and skill and ability in that could be tapped. There was discussion of a possibility of an anonymous complaints process. Well, as it is now, the Law Society can, of course, initiate its own complaint where appropriate. An underlying theme, again, was entity regulation, because practices and policies and training are done by firms, not by individuals, by and large. And a discipline process which is based on individuals and not on what might be the underlying difficulty or asserted difficulty brings that issue, again, crossing over into a different working group of the Law Society. There was discussion of third-party complaints in terms of organizations being able to bring complaints. There were suggestions about auditing firms for policies and practices, and that would be in tandem with the self-assessment by firms of themselves, which of course is advanced in several countries as a means of proactive enhancement of ethical standards, and the same thing can be applied to equity issues. In terms of the operations of the Law Society has received support from participants for its proposals to enhance its current equity compliance program, to conduct an internal equity audit, to collect further data on the regulatory process, and to develop a more diverse public face or image for the Law Society. A number of participants emphasize that the Law Society must model the change that it is seeking to create in the legal profession, which would include an increase in diversity at both the governance and the staff levels. Indeed, there were comments that are noted in the status report by participants at some of the open houses about the relative absence of diversity of racialized licensees at the meetings at which they were leading, and that became a point of discussion with participants about diversity of convocation, about diversity of meetings. But they also expressed satisfaction at these meetings that though there were those from the dominant culture who were interested in being part of change and in hearing from licensees on these subjects, which of course we know Convocation is supportive in principle of these efforts. So where we're at, it seems that as Ms. Lieber was saying, we may be at a certain inflection or turning point in terms of what can be done. The working group is going to be moving forward with meetings, including this afternoon, with the goal of bringing forward concrete and doable recommendations to Convocation in the fall. There is a great deal of public consciousness in the legal profession and more broadly of these issues. The time may be opportune for manageable and effective change within the proper mandate of the Law Society, because it's clear that greater equity and diversity are critical to the long-term success of law firms, as well as equal opportunity, access to justice, and simple fairness. And so the working group is going to be moving forward with an effort to put those high-minded principles into application and bring it back to you at Convocation.
Thank you very much, Mr. Annan. Are there any questions of Ms. Rannan or Ms. Lieber? In that case, thank you very much. And I guess I should ask if there's any questions or comments on the
The
phone.
conference is no longer in lecture mode.
Any questions or comments of Mr. Annan or Ms. Lieber? Thank you then. And then we'll move
The
next
conference is in lecture mode.
to the report from the Discrimination and Harassment Council. Ms. Lieber, were you going to speak to that?
Yes, briefly.
Thank you.
The discrimination and harassment report Convocation begins at page 406 of Board Books. And the report describes the work of council from the summer to the winter of 2014, July to December. There's one phrase that stands out in this report, and it's worthy of underlining. It's in paragraph 3. The Discrimination and Harassment Council provides safe counsel. It is the Office of Safe Counsel. It's a place for lawyers, paralegals, clients, the public, and students to bring confidential concerns about discrimination and workplace harassment forward. And there they can receive referral, coaching, options, mediation, and information. So during this past reporting period, the office fielded 109 contacts, and of these, 20 were general inquiries, 45 were outside the mandate. 18 were complaints against lawyers by members of the public, 16 were complaints against lawyers by students or other licensees, and 2 were complaints about paralegals by members of the public. Most prevalent complaint you will see continues to be sexual harassment complaints, followed by disability and race-related complaints. And the office fulfills a very important function. As the website says, discrimination, harassment, or demeaning practices that attack the dignity and self-respect of the victim. Discrimination and harassment poison relationships and can cause workplace problems such as low morale, reduced productivity, and the loss of valuable employees. There will be a newly revamped website live shortly for the interest of members. It's fully accessible and will provide clear information on the services. It may be a nod to our prior report on challenges that making these services as widely known as possible may be a potential piece of the policy puzzle to provide a confidential space for the anonymous complaints that some people wish to make that might not belong in the formal discipline stream. But it does allow for support, etc. So I will close by thanking and acknowledging Ms. Peterson for her work on behalf of the Law Society and for this report on her activities.
Thank you. Again, any questions, comments?
In the room? From the phone? Oh, sorry, Ms. Potter.
Thank you, Treasurer. It's really just a comment. You know, this is such a valuable service. It's been around now for quite some time. Ms. Peterson does a terrific job, as do the alternates that work with her. My only concern is that when I've mentioned this to some of my colleagues, they don't know anything about it. And, you know, people don't just go on the Law Society website for no reason. And as a rule, they usually have a reason for going there. And it just seems to me that if there's some way from time to time we could do sort of broadcast emails, like an ad almost, going out to people saying, you know, have you been sexually harassed or whatever you want to, I'm not the wordsmith on this, but it'd be nice to try and perhaps bring it to their attention so they know it actually exists, because we know it's a needed service and it's probably not utilized as much as it should be if people were aware that it exists.
Might be worth mentioning that on May 6th, the panel on mental health, Ms. Peterson will be part of that panel, and there's been a blast of the profession, so maybe that's a start towards what you suggested.
Thank you.
Mr. Faulkner?
Just in response to Ms. Potter's very good point, she should know that there are regular bulletins in the ORs as well as literature that goes to members regularly. So perhaps we can better educate ourselves in terms of what that looks like for the next convocation.
Thank you. Okay, and then next we have you, Mr. Faulkner, snapshots of the profession.
Thank you, Treasurer. Treasurer, for my colleagues' assistance, I'm at page 389 of board books. Now, there is a risk, looking at the statistics, starting at page 389 of board books, that go all the way through to page 405 of board books, that I'm going to inundate you with statistics. And Madam Treasurer, I assure my colleagues that's not going to happen, since half the time I'm probably not even professionally capable of quoting them.
We can read them, Mr. Faulkner.
That's right. The arguable. The importance of what is set out at board books is, in essence, the product of a great deal of hard work combining our equity department with the good offices of Professor Michael Ornstein, a sociology professor at York University. As a result, responses given on the LAR from 2013, the lawyer's annual report. And if you look at page 389 from board books for a minute, you're going to understand the significance of the response data. I'm before you as a co-chair of Equity and Aboriginal Issues Committee to sort of give us a report card on how we're doing on issues of diversity in the profession, and a report card on areas that are of obvious pride that we've made progress on, and areas that we need work on. And what you're going to notice from some of the statistics and information I pass on to you in the quick 10 minutes I intend to speak is that, first of all, there is a very significant dovetailing with the work by the challenges faced by racialized licensees. That is exactly what we're hearing anecdotally or through submissions, we're seeing statistically in terms of who faces the greatest challenges, who's having the most problems. And I think that's important because it shows that we're on the right track in terms of what we're grappling with. Now, I want to go to some of these statistics, but I want to start with the response rates at 389 so that people have a sense of the size of the data and the reliability of the information we're looking at. At page 389 of board books, the first thing you're going to notice is a little paragraph about response rates. The only reason I'm drawing this to your attention is historically the way we've managed self-identification issues with our membership is we've given them an option basically to pass on the answer. So not fill out a box that says I don't want to answer, but actually just not address the question at all. You can just keep going. What we point out at the top of page 389 of board books is that we've changed our approach. People are free not to self-identify, but we ask them to tick a box that says, I prefer not to self-identify. Interestingly enough, and there are brilliant sociologists who understand that better than I do, the response rate zooms up. People direct their minds to the question, oh yeah, I guess I'll answer that. It's very interesting when you look at the response rates that in respect of, for example, gender, which is the last you see on the response rates, in respect of gender, you see 100% were comfortable responding. When it came to issues of race or identifying one's sexual orientation, the numbers changed, but they're still very strong. In terms of Aboriginal, it's 88% response rate, racialized 77%, Francophone 91%, etc. Very high numbers. If you look at the bottom of page 389, you'll see that the total respondents to the question about race was 29,797. We're talking serious numbers in terms of the response rates and the number of people, of course, that have to fill out LAR as part of their job. So what did we learn, first of all? Well, we know this traditionally, but you'll see it set out at page 389. The first thing that you'll know is that, not surprisingly, the white representation in our profession is disproportionately higher than they represent as part of the population. So while 71.8% of the Ontario population are white, 81.7% of the lawyers are white. On the other end of the spectrum, what you'll see at page 389, and I'm giving you some quick stats, whereas 2.3% of the Ontario population are Aboriginal, only 1.4% of lawyers are Aboriginal. Whereas 26% of the population of Ontario are racialized, only 17% of lawyers are racialized. At page 389, you'll see the entry for black lawyers, and I'm going to come back to this because it's of some note that I feel obligated to educate Convocation on. You'll notice that 4.3% of the Ontario population are black, 2.9% of lawyers are black. What we learn as we go through these statistics is that there is very significant progress for many racialized lawyers. There are many groups of the 8 groups that we identify in which their numbers go higher. And how do we measure whether numbers go higher? Professor Ornstein uses age categories as a strong way to figure this out. That is, if you look in the older cohorts, say 50 to 59 or 60 to and onwards, you'll see a small percentage. When you look at the young lawyers, they get a lot bigger. That applies for South Asian lawyers, that applies for Chinese lawyers. But interestingly enough, there are 2 categories, surprisingly and of concern, whose numbers have not increased. At page 390 of board books, the next page, you'll see in respect of black lawyers that actually the under 35 category is 3.0%, whereas the 45 to 54 category is 3.8%. In other words, they're one of the few groups, the only group of racialized lawyers who actually have decreased. They're accessing the profession in less numbers, not more numbers. When you consider the challenges faced by lawyers' reports, the submissions, there's some real dovetailing there. Similarly, the same thing applies for Aboriginal lawyers. Now, that's obviously of concern. There's 8 racialized groups, and if, for example, you look at Arab, Chinese, Latino, South Asian, West Asian, you'll see that in fact in the younger cohorts, their numbers double or nearly double. So you're seeing some racialized groups progress in terms of accessing the profession, and I want to stop and say there's an underlying premise. The premise is that accessing being a lawyer is progress. There are some who might see it differently, but we're going to assume for a moment it's a good thing to be a lawyer. And what we really want to assume is that our doors are open. That our doors are open and that access to the profession as an essential part of access to justice is in fact there and there in an equitable way. You'll see at page 397 of board books, we look at the disability question. It's 397 for the lawyers and 405 for paralegals. And what you'll see at 397 and at 405 of board books, those two pages, one for lawyers and the other for paralegals, is that we've tracked the data on lawyers self-reporting for disability and on paralegals self-reporting for disability. What's interesting is if you compare those two pages, predictably, paralegals, like you'd think most people, have an increased incidence of reporting disability as the population ages. Lawyers, on the other hand, inexplicably, as Professor Ornstein points out in the data, and he feels more work needs to be done, lawyers inexplicably do not have an increase in reporting disability. Dr. Ornstein has told the committee that he believes that there has to be stronger assurances of confidentiality to lawyers, and he believes that there is an issue of self-reporting because there is an inexplicable, there's a non sequitur there. There's just a disconnect between what we're seeing with paralegals, the population, and what we're seeing with lawyers. And as I said, you'll see the lawyer disability numbers at 397 and the paralegals disability numbers at 405. One of the things I want to emphasize, and I'm trying to move quickly so that I don't get in the way of lunch. Getting in the way of lunch for a bencher can be very career limiting. One of the things I want to emphasize is that for paralegals, that distribution of racialized groups is actually very strong. In the case, for example, of racialized paralegals, they actually are represented at a higher percentage. That is, paralegals occupy a higher percentage than their population numbers would suggest. So, for example, racialized folks make up 26% of the Ontario population, but racialized paralegals make up 33% of their numbers, telling us that opting to be a paralegal is strong amongst racialized groups. I want to speak to you briefly, again, tying back to lawyers. I want to speak to you about an interesting stat that's at 392 of board books. And again, it helps us with some of the challenges working. There's significant differences amongst the 8 racialized groups in terms of where they're to be found in business. This is at 392 of board books, and how they opt. But we see certain patterns that we have to confront as a profession. It is apparent that racialized groups form less numbers as law firm partners and less numbers as law firm associates. But what is stark at page 392 is look under the category of black lawyers. They form the easily highest level of sole practitioners. 36% of black lawyers are sole practitioners. Now, why is that? And again, the work being done by challenges and the perceptions and concerns by communities is obviously reflected in some of these numbers. We see that Aboriginal lawyers are less likely regionally to be found in Toronto. They're more likely to be found in Northern Ontario or Ottawa. We see that Aboriginal lawyers and black lawyers are more likely to be found in smaller settings. We see that Aboriginal lawyers are more likely to be found in government. We've also done data for LGBTQ communities. And you'll find some of that data at page 398 of board books for lawyers and 405 of board books for paralegals. Suffice to say that Professor Ornstein observes that many of the institutional barriers that other minorities face are also faced by the lesbian, gay, bisexual, transgender, and queer communities. So what that tells us is we are identifying data that reflect in some cases very positive trends and in other cases sources of concern. What I would say as a profession is that we clearly have done well in some areas. When it comes to, for example, the prevalence of women in the profession, it's extraordinary. We are well over now 55% in the young cohort of women entering the profession. Very strong. We seem to be, quote unquote, stalling in other places. We have to ask ourselves why. And we have to have real dialogue with our partners who are experiencing this. And I say that the latest bench that's on its way in this election, I hope to be talking to them from within these walls and not from without. I say the latest bench that's coming in is a very strong indicator of the sea change in terms of the diversity issues. Thank you, colleagues.
I would just like to point out that sole practice outside Toronto is the best form of practice there is.
An infomercial. Okay, thank you. Any questions or comments in the room for Mr. Faulkner? Okay.
This is one question. I'm not sure the number refers to the racialized and white at 12%. What is that?
Where are you? Which page?
Excuse me. E92.
Do you not only want me to read this thing, you want me to interpret it? Which? Under what?
The racialized and white. Under sole practice. Under sole practice.
Right, that's someone who's, that's right, that's,
Category, racialized.
that's it. That's someone who's identified in that category.
It's me.
We don't get it.
So for example, if you had a father who's black and from Jamaica and a mother who's white and from Poland, you might put racialized and white. Oh, that sounds familiar.
Or depending on religion, perhaps.
Could be.
Thank you. Any questions or comments from the phone?
Conference is no longer in lecture mode.
Thank you. That
The
completes.
conference is in lecture
Report.
mode.
Thank you very much, Mr. Faulkner. And next we will have the Heritage Committee report.
Thank you. I will try to be brief. The name Shirley Dennison will be familiar to almost everybody in our room because of the terms of his will. Former treasurer with a career worthy of study all on its own, managed to leave the residue of his estate to the Law Society to be used from time to time for the relief of impoverished or indigent members of the Society and their wives, widows, and children, including wives, widows, and children of any member of the Law Society who may have been disbarred and suspended. And I think in part it was that last bit that gave the Dennison will that legendary status it came to occupy, because I recall at the bar admission course when we discovered that a treasurer had left money for the families of disbarred and suspended lawyers, we thought there is hope for all of us. In any event, last year we spent it all. We went from... It is sad. So, having spent down $432,000, 134 beneficiaries over the years, the Heritage Committee thought we shouldn't let this name disappear. As succeeding groups of benches are elected, they soon will never have heard of Shirley Dennison, and that seemed wrong. So we decided to nominate, and we have done so with the unanimous support of the Access to Justice Committee, that we create a new award called the Shirley Dennison Award, which will be awarded annually for a member, lawyer or paralegal, who has demonstrated an outstanding contribution to efforts to promote access to justice and or address poverty issues. And we wanted this to be a fairly seamless new award, one that could be adjudicated by the same committee that does our other awards, one that could be awarded in the same occasion, thus causing us virtually no extra work and hardly any extra cost. So that's the proposal. I'm moving that we create this award, the full terms of which are in your materials, as it's seconded by Virginia McLean.
Questions or comments in the room? Ms. Potter?
Thank you, Madam Treasurer. You know, you talk about the new bench coming in, and they may not know who the Shirley Dennison Award is, what that person is. And I'm going to suggest that we call it the John Shirley Dennison Award, because I think it's very confusing. I think people think Shirley Dennison is a woman.
Yeah.
And it could even be Treasurer John Shirley Dennison Award. I don't know, but I just think I'd like to have some way of identifying the fact that this person was Mr. John Shirley Dennison. So,
That's fine. I wouldn't put treasurer in because, of course, Laura Lake was a treasurer as well, and that seems we would have to start thinking about changing all of them. I think, sure, John Shirley, he always used J. Shirley, but nonetheless, I have no objection to a John Shirley Dennison Award.
Those last words were "call me Shirley."
I wondered what the award was going to be.
Just a certificate, really. Whatever we give for the others is we did not want to strike a medal or anything expensive. We are just, it's the honor, it's not the thing.
Yeah, I'm sure the committee will address what is
Yes.
the appropriate manner of recognition. Any other questions or comments on the phone?
The conference is no longer in lecture mode.
I'm hearing any. Let's move the question. All in favor? Any opposed? On the phone, any opposed? Motion carried. Thank you very much.
The conference is in lecture mode.
I don't like it. Professional development and competence, Mr. Goldblatt.
Treasurer, I hope to be brief, but I've learned that's not usually my call in these presentations. This is found at page 434 of board books. It is a motion that is moved by myself and seconded by Ms. Murchie. The Convocation approved the elimination of continuing professional development desk audits. And for the information of Convocation, if you look at page 436, you'll see that when the Convocation approved the CPD in February of 2010, there were 3 recommendations with respect to auditing. Recommendation number 16 provides for random annual audits of those who are involved in either a practice management review as a lawyer or a paralegal practice audit. And that is not the subject of this motion. The motion rather directs to recommendations 17 and 18, which allow for randomly selected CPD audits, which is really, as it says, a form of a written request for proof of completion, and also provides that there be 500 audits of lawyers and 25 audits of paralegals annually respecting the CPD compliance. And because they do not involve a visit, they're colloquially referred to as desk audits. And following paragraphs describe the records that need to be maintained, but more importantly, if you turn the page, you'll see some compliance statistics. And just before the compliance statistics is the summary that of the 1,854 CPD compliance desk audits, those are the ones I've just referred to, less than 0.3% were not in compliance with the record-keeping requirements. A slightly higher incidence of non-compliance has been found through the in-person CPD audits conducted during the reviews of licensees that I've already described for those under what is recommendation number 16. So having evaluated the process and taking a look at the cost and effort involved in doing the desk audits, It is recommended, and which can be seen at the bottom of page, well, the recommendation in any event, that the committee change the CPD audit requirements and eliminate the desk audit process. It not only really removes a sense of audit that does not appear to have any practical benefit, but it also will have staffing implications which are set out in the material. So, as I say, the motion is fairly straightforward. It is moved by myself and seconded by Vice Chair Barbara Merchant.
Questions or comments? Mr. Goldblatt? Right, any questions or comments on the phone?
The conference is no longer in lecture mode.
Hearing none, we'll call the motion. All in favor? Any opposed? Any opposed on the phone?
How refreshing. Thank you.
Congratulations, Mr. Goldblatt.
I really appreciate it. Big accomplishment, sir. Wow, major victory.
Next, we're going to have a report from the Mentoring and Advisory Services Proposal Task Force. This is an interim report. Mr. Wardle.
So I am going to just outline what we've been doing a little bit, and then I'm going to turn it over to my co-chair, Ms. Rothstein. Let me start with this. Many of you may have wondered what the Mentoring Task Force has been doing. And the answer is we've been working in secret all this time. Mr. Faulkner, who's a member of this committee, has told us that he doesn't believe in transparency for this particular committee, and he would like us to conduct all of our deliberations in secret.
I believe that's a quote.
So it's with some reluctance that I come in front of Convocation today. But if I go backwards, our current strategic plan relating to post-licensing competence included developing initiatives in this area. And this task force was appointed by the previous treasurer in November 2013. We've had 6 meetings since that time. We initially started out by doing a kind of a literature review of what's being done both in Ontario, in our profession, and around the world. And we concluded fairly quickly that there's many legal organizations that have voluntary mentoring programs, which are limited in scope to really what I would call networking and support. But we identified what I would call as a gap, and the gap is that there is a great need and opportunity out there to provide services, particularly for young lawyers practicing outside the large firms, that are aimed at something more specific, that we've called in this report advising and coaching services. And you'll see if you look at the interim report, which is quite brief, it starts at page 521 of Board Books. We've outlined a list of factors, which is really, I would describe as more of the thinking of the committee at this point, and that is set out at page 526. And I'm just going to go through a few of them quickly. They'll be, for many of the people in this room, I think people hopefully will be nodding their heads. You'll see we start by saying mentoring and advisory services are linked to a post-licensing preventative competence strategy that may enhance practices and assist practitioners to avoid discipline or other conduct streams. While mentoring is used in the traditional sense to mean networking and general career advice is a valuable tool, what is better described as an advisory and coaching program may more effectively address licensing needs. And then we go on to say that a well-focused system of advisor and coaching services designed to support the needs of lawyers and paralegals who might not otherwise have practical guidance from experienced colleagues may address a gap in the professional development of such legal practitioners. Now, it's not that we don't provide information to young lawyers, because we do. We provide a lot of, this organization provides a huge amount of information. And as everyone knows, all the legal organizations in the province have various outreach services to try to reach young lawyers. So the real question is, we've identified that sole and small firm practitioners, and I'm particularly thinking of young lawyers, may lack the contacts and advisors who can help them distill the wealth of information, apply it most effectively, and develop advising relationships that can become part of their professional development plan. So that's the need. And then you'll see we go on to say that it could extend to things like completion of legal tasks, daily management of client files, substantive and procedural issues relating to those files, and practice management obligations. In other words, we could come up with an outreach program that would provide some very specific, focused advice to young lawyers. Now, that's the goal. We've been working towards developing a proposal. We actually have a proposal in draft. It's not quite ready for this group, but I expect we'll have it ready sometime in the early part of the next term. That's sort of what the committee has been doing and where we are right now. We're also in a strategic planning process. It's going to be very important to see whether we identify this as one of our strategic priorities for the next term. And hopefully everybody in this room who's involved in that process will identify it as a priority. We're also working very closely, obviously, with the Racialized Licensees Working Group. And from what we're hearing from those consultations is we're hearing that the response is that there's a need for these services right across the board. So that's kind of where we're at. I'm just going to turn it over to Linda. Linda and I obviously both feel strongly about this initiative, and we hope that all of you are going to support it.
Well, it's really very gracious of Peter to suggest that I should chime in at this point. I think it has a lot more to do with Peter thinking that I would be nostalgic about my last convocation and I should be given one last opportunity to tell you how I really feel. So at the risk that this last opportunity to address convocation will be little more than passionate advocacy of the obvious, let me just say this. We all know this to be true. Behind and beside every good lawyer and every good paralegal, and behind and beside every great lawyer and every great paralegal, there is at least one other lawyer, but more often a group of lawyers or paralegals who are not just mentors, but they're advisors and they're coaches and they're sounding boards. And we are, after all, in the business, when we provide legal services, we're in the judgment business. We have to exercise good judgment and pass on that good judgment to our clients. And I think most of us know that it's really hard in the complex situations that we all deal with every day. Clients come in and they have problems and there's deadlines and difficulties, to exercise good judgment without talking to others who've done it before and know how to do it better than you. The provision of legal services is, in this day and age at least, way harder as a solo sport. And so the thinking is, and it's been very much confirmed by what we've heard the task force, the working group on the challenges for racialized licensees has heard, is that it's not just about mentoring, it's not just about networking, it's not just about building your career and feeling part of the profession, although that's absolutely very important. It's about actually having access to people who know how to practice what you're trying to provide to your clients, and having the opportunity to discuss with them real problems, real ways of doing things better, real ways of providing good legal services across the province. So we think the need is obvious. We think we don't need to persuade you of the need. In fact, I remember for the last 8 years hearing on the lips of all of my colleagues around this table at one time or another two things: access to justice, mentoring. So my pitch is really this. We need the collective resolve to put our money where our mouth is. We need the collective resolve to put our money where their mouths are. And my mouth won't be there anymore. It will be your mouths, those of you who are continuing as benchers, to put this at the top of your priorities, to embrace the idea that while the Law Society will never be the only provider of mentoring and coaching and advisory services, and we would never suggest that we need be, it can lead in this area, it can develop a pilot program, it can offer, particularly to younger members of the profession and those in sole and small practices who don't have access to advisors and coaches, real, substantive, procedural, file management guidance that will make them the good lawyers that Ontario deserves. So I say this to all of you. As you all know, I'm a big believer in renewal. I think this convocation is going to be better for all the new faces that will join all these other older or at least more experienced faces around this table. I think that's going to be terrific. And I think that it's going to create, a whole new assessment of what the priorities are. But I also think that all the returning benchers, and there will be so many of you, I hope, all of you have an obligation to ensure that we don't just start from scratch every 4 years, that we do continue along on pathways that we've started, that we finish the work that we've begun. This is one of those projects. We've done a lot of work. It's a long way along. It is worthy of your top priorities come September. Thank you. I much enjoyed being with all of you. Oh, thank you very much. Oh, yes. Okay, Mr. Brett, sorry, and Mr. Faulkner, sorry.
I'll just stand here.
Okay, sure.
So I just want to echo what Peter and Linda said. I've been saying from the beginning, we regulate the profession in the public interest. And the reality is competence and ensuring that lawyers are competent when they provide service to the public is really at the heart of what we do. And the reality of the situation is when we call people to the bar and they go off to practice with Linda or with Peter, they get great mentoring, they get great training. But the people who don't do that, that's where we have to focus. Because nobody on the first day after they're called to the bar are competent to practice in all of the areas that we license them. And the only way we can ensure the protection of the public, which is at the core of what we do, is to make sure that those people in their early years of practice get access to the type of mentoring and supervision that people get when they go to Peter or Linda's firm. And so I rise because I do think this is something that is really important. It is so close to the center of our mandate that we have to continue it on. Thank you, Treasurer.
Thank you very much. Mr. Faulkner, will you be brief, please?
Through you, Madam Treasurer, to my colleagues on the task force, I just want to say, first of all, thank you for their leadership on it. I think the bottom line to this is that for too long, this has been a discussion piece, a matter of platitudes. And part of and I put this on the record in front of this convocation because we as a group of benchers are responsible for the good and the bad. Part of the problem is our unwillingness, honestly, to spend money on this. I hear these strong reports by Chair McGrath about LawPro, the monies that we've seen out of our investments in LawPro. I hear the good news from Mr. Brett about our budget numbers. Why can't that money be used to help those who are struggling? We see references to 36% of black lawyers being sole practitioners. We know the truth that those in the small settings who face the greatest challenges, just as Linda described, as Ms. Rothstein described, the reality is we have to stop talking and actually do it, which means take resources, spend them at two levels. The first level is the reality of practice advisory. We have to recognize it's not just about how to be a lawyer, it's about how to help people with their files, because these folks in supportive settings get help with their files. So
Mr. Faulkner, I really hesitate to interrupt you, but this was an interim report, and I think we are grateful for your comments. They can be made when we come back to them. I'm just concerned because we have 2 decision items we have to deal with
Fair
in
enough,
camera.
I'll wrap up in 20 seconds.
All right, thank you.
Okay. Practice advisory is a piece of it. So as benchers, we have to start talking about the issues around privilege and whether there's a way to extend the branch of privilege and the protections of privilege so that people can get real advice and we can stop all the fictions. The other piece, and I am wrapping up, the other piece to this is the recognition that there has to be a level of cultural competence by the people we're asking to help others. This isn't a pro bono volunteer exercise. This is an exercise where we should have professional expectations about those giving the advice and the guidance. I say those 2 things because I ask my colleagues to continue to think of these in the forefront when you think of mentoring. Thank you for your patience.
Thank you very much. We have also listed for information a report from Mr. Mercer on compliance-based regulation, and I'm just going to ask, can you give us that in 3 minutes, possibly?
Yes.
Thank you.
Clock's running. This is merely an information report updating for Professional Regulations Committee the ongoing work principally of staff to bring forward a framework for the consideration of compliance-based entity regulation. The point of compliance-based regulation is the observation that if we plan through policies, procedures, cultural change to avoid problems, we will deal with fewer problems by way of retrospective discipline. We wish to avoid creating errors and harming clients, harming the public interest, rather than mopping up after them. The second observation is that many of us practice in groups. Many of us do not, many of us are in sole practice. But many of us practice in groups, and where we practice in groups, it's necessary for compliance, for proper policies, procedures, and cultural change to occur, for that to happen by the group, for the group. The current big issues or main factors for consideration are set out in paragraph 51 at page 554 of board books. For lawyers and paralegals who practice in groups, the question is, should there be a lead in this respect to deal with the law society and to have a degree of responsibility? That's called a legal director. What that person does, what their responsibilities are, is part of the discussion. The second is the concept of ethical infrastructure, a fancy academic word for what I've just called policies, procedures, and culture. How we do things, how we organize as groups in advance, and as sole practitioners, how we plan for problems and to avoid problems. The third aspect is for groups, we could call them firms. What sort of rules should there exist where lawyers and paralegals practice together? One example, and it's only an example, is policies and procedures on conflicts of interest. We know that where lawyers and paralegals practice in groups, that matters, not just the individual response. Mr. Anand's reference to possible outcomes of the challenges process to deal with other matters where group conduct, group culture, group practice need to be addressed is a similar point. The last point I'll make in paragraph 8 is one of the open questions is whether or not we look only at trying to create positive policies, procedures, and culture, whether we have specific rules, specific policies, or simply require or ask that they be there and provide assistance, whether they be mandatory or not, and whether or not firms or entities or whatever we want to call them, I prefer to think of them as groups of people, have obligations with respect to their collectivity vis-a-vis the law society in terms of reporting, in terms of outcomes. So that is, I think, less than 3 minutes. What I simply want to do is report that this is an ongoing project, and I think an important one.
And I would suggest if anybody wants some further discussion of that, perhaps they could engage Mr. Mercer or someone from the Professional Regulation Committee later on, because it will be an ongoing effort. Thank you. Okay, thank you very much, Mr. Mercer. I think we're ready now to move into in camera.